with my fellow commissioners. I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device like a cell phone, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda available.
In the back. Yep.
Available at the back of the room. Good. And it's been provided to folks electronically as well. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be, the commission will vote on those cases and they will not be considered further today. And so it's time for us to consider adopting that agenda and consent agenda. I'll entertain a motion.
Move adoption of the agenda and the consent agenda.
I'll second it. So for folks who are watching, because we have people participating remotely, we are going to be using our remote participation policy, which means that every vote by commissioners must be able to be observed both visually and auditorily, which means that every single vote, I will ask each commissioner to vote separately. So the motion is to adopt the agenda and consent agenda. If you are in agreement, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes. All right, and next on the agenda is our adoption. I'll consider a motion to adopt minutes of our last meeting.
So moved.
Second. So it's been moved and seconded to adopt the meetings of the April 2023 meeting. If you're in agreement, you will vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes. And then Amy, our director's report, please.
Yes. Good morning, commissioners. And it occurred to me that we don't do something that we probably should. We used to have name plates that went in front of the commissioners, so people watching would actually know who you are. And since we don't have those, because we haven't met in person, we're just meeting in person again, maybe each of you could introduce yourself, because that might be helpful to people who are watching. Why don't we start here?
I am Commissioner Thomas Douglas. Morning.
And David from Farmington.
I'm Jeff Ashby.
I'm Mark Walker.
Julie O'Brien from Augusta. Thank you. Sorry to spring that on you.
Yeah.
So director's report. Yes, you have a memo from me on personnel, which says essentially there are no changes in personnel. The only change that I didn't put on there is that I have given my notice to the governor's office that I will be leaving the commission as of mid-August, which you already know. As does our staff. Stop it. That's very funny. And Jane O'Reilly, I think I put on there, she is out on maternity leave. She just had her baby on Friday.
Okay.
Saturday.
Very, very early Saturday morning.
Very, very early. They're all doing great. For compliance, you have a memo that purports, I think, to be from me. It doesn't even say. You have a memo that shows that since our last meeting, there was one successful conciliation, and the memo is status of reasonable grounds cases. There were 4 unsuccessful conciliations, and there are 4 conciliations that are pending. And I believe, I don't know if each of you saw, but the one successful agreement, we finally came to terms as of late last week. So Kit brought in person to you a, I think, printout of the agreement in Cassavant versus UMS.
I did not bring it. You have the only copy.
Okay. Sorry,
but you have
by email. Kit sent you the actual agreement.
right.
They're all looking like, oh my gosh, we have actually.
The James memo that is actually that purports to be from you summarizes the PI remedies,
Which is also an email
also in the
that they don't have because their Wi-Fi is turned off.
Yes,
I see.
but they have the memo.
You have the memo. Okay,
Yes,
so the
they
memo,
have the conciliation memo and James memo recommending approval.
the memo was in the stuff that was uploaded to them.
No, because I got it this morning,
Okay,
but it has been emailed to them and they have a hard copy of it in front of them right now.
you have a copy in front of you right now. Okay. Oh, You can see we're pulling ourselves together here. The hybrid process is a messy process and we're working on it. So if you want to take a minute and look at that, this is a case that you all, I think, are familiar with. It's a good resolution with remedies both in the complainant's interest and also in the public interest. And so we would request that you approve the conciliation agreement and sign it. Once you had to, yep.
Question.
Yep.
When is that effective, obtain the healthcare policy that provides gender affirming care?
They have a year to find that, because I believe their bidding process happened in March. So I don't know, the reason they have a year to do that is because we don't.
So not necessarily this September, but.
Right, so they, from what I remember from the record, the bidding process for the student health insurance happens in March. So they will have already picked a plan for this coming year, but next March, they will pick a new plan unless they can get one before then, and they are updating us every 30 days as to their efforts.
Thank you.
You want a motion now?
If you would be so kind. Or someone would.
I move that we approve the conciliation agreement, EDPA 20-0470.
Second.
If I could suggest, Commissioner Ashby, that you may want to recuse in that.
Oh, my God.
Yeah.
Thank God.
If you withdraw your motion and withdraw your
Absolutely.
second,
I might withdraw myself from the room. Shame.
do not.
Yeah. Trying to be helpful. I don't see how that hurts
I know
anybody.
you
No,
are.
I'm kidding. I apologize.
If someone else would be so kind as to make a motion.
Adoption of the conciliation agreement.
Thank you, Brian, you seconded. Yeah. So the motion is to approve the conciliation agreement in EDPA 20-0470. If you're in agreement, you will vote yes. Commissioner Ashby.
Abstain.
Excellent. Commissioner David,
Yes.
Commissioner O'Brien. Yeah. Commissioner Douglas,
Yes.
Commissioner Walker.
Yes. Wow.
It's gonna be a day. It's gotta be a day.
It's already been a day.
Yeah. And before we leave, I will ask Commissioner David if you would sign that on behalf of the commission.
Sure.
Next, we have just a report on investigation. I believe you have from me somewhere a memo that outlines what's been happening in terms of investigation in the month of April. And it shows it's titled April 2023 Case Activity Summary. And it says that in April, we received 39 new charges. We resolved 40 charges. The report shows you that there were 14 administrative dismissals and the basis for those. And there was one withdrawal with benefits and 18 no reasonable grounds closures. Those are from a commission meeting. So litigation, I would ask that we take after executive session. And that's all I have before new business. In new business, I would just mention that the legislative session continues to be very busy and challenging. Last week or the week before, there were still new bills coming out of the revisor's office. A lot of them have been related to the Maine Human Rights Act, seeking to add new protected classes. Most of those bills have now died. The commission was neither for nor against all of those bills. I think we gave you a folder in the materials to show you the most recent legislative activity. The governor's biennial budget proposal remains ongoing. This is part 2 of the budget process. What should be the long session of the legislature this time has been divided into 2 different parts. First, the continuing services without new things, that's already passed. Now, new proposals that relate to different agencies. We had 3 initiatives that were in that part 2 process, new money. One of them already has been added into the governor's budget by the appropriations committee. That didn't really call for new money. It was just shifting money between state funds and federal funds. The 2 new positions, which are to us, I mean, obviously all of it is important, but this is the most critical need right now, is As of the last time I checked, listening to appropriations hearings, it's the only way you find out, as far as I can tell, what's in and what's out. And the last time I listened, they were not yet at new position, and ours was still sitting there waiting to be discussed, because my understanding is that they address all the new positions sort of at horse trading. I've been told that there's no reason to believe that our things wouldn't end up in the budget, but I will believe that when I see it. And here's why it's so critically important. We are, and I think we've told you before, that we are crushed with hearing cases, right? I'm sorry, housing cases. Housing, as everybody in the state knows, if you read the newspaper, housing is incredibly volatile and challenging. And that continues to affect the commission as well. And here's why. And this is what we outlined to the legislature and the governor's office, is that housing cases are super fast tracked. They have to be done in 100 days, whereas otherwise we have 2 years to investigate. Cases that are dual filed with HUD require twice as much work for documentation purposes and HUD databases. And every single case in which we find reasonable grounds in a housing case that's dual filed with HUD, which is most of our housing cases are dual filed. If we find reasonable grounds and don't resolve it in conciliation, we have to file a case in court. Right? We don't have discretion about that. So our resources are being taken up more than ever, right? So we're still 6 weeks away from the end of the fiscal year. We have more housing cases filed in this year than we have ever had before. And we're not done with the year yet. Some weeks we get 1 new housing case, some weeks we get 5. So if more housing cases means that's less that we can do. We can't get to other cases. We have, for the first time, had to tell EEOC, which every year they say, here's how many cases we expect you to close based on what you produced last year. We had to tell EEOC to cut our contract by about 1/3 because we cannot close those cases, which we've never had to do before. We've cut a few cases here or there. We had to cut off 75 out of 300 cases. That's a lot. Now the money, HUD cases pay a lot more, so we're not going to be out the money, but the ability to close cases is really huge. So that is, I think it's just really important for all the commissioners to be aware of just how much the housing crisis is affecting our agency and our ability to close cases. And I've told the governor's offices, I've told the legislature this, if we do not get the position, the new investigator position and the new business manager position, we will be really, it would be very detrimental. So I'm watching it. I have very little control at this point because all the discussions happen behind the scenes. So when I say we're told that there's no reason to think it won't get in the budget, that is modestly reassuring, but I'm very concerned that if we don't get it, we're really going to be in a tough position. So that's my spiel. And you wrapped up a HUD grant. That's all I have. Yes.
I have a question and maybe we talk about it later, but I think we kind of brushed this at another meeting, but in reading the legislation, the testimony, and it was brought to my attention when you testify, it's on behalf of the commission.
Correct.
So do we see those beforehand? Because
No.
Okay. So shouldn't we, if you're doing it on behalf of the commission? I know it's at a time, I mean, I get it about the staff, but if someone said you know, asked me about one particular bill, you know, asked me particularly about it, and I said, I don't know about it. So should we? And tell me it's too, you know, it's too unwieldy to do. I do get that. But
So there's a couple of factors, and there's what the statute says and who does what, and I know Barbara is thinking about that. But there's also the practical, never mind the fact that there's no time because legislative hearings happen very quickly.
Yeah.
The other factor is that the structure of the agency is that commissioners are volunteers, right? You get paid per diem and you're statutorily tasked with administering the Maine Human Rights Act and the agency, but by statute, you hire an executive director to do the administration. The ins and outs of our funding sources, of our budget projections, of our budget to actual, of the funding allocations for our positions. It's impossible for you all to even know that, never mind to know it well enough to have an educated position about testifying about it. Because you're not employees of the agency. In some other agencies, in agencies like ours in other states, the commissioners are actually employees. But that's not how the Maine Human Rights Act is designed. And I don't in any way want to diminish the importance of what you're doing and the fact that by statute, you are the commissioners. And you, by statute, delegate to an executive director to do the administrative actions for the agency. Yeah.
Thank you, Julie. I raised this last
I thought,
meeting, and I remember it because I compare it to another statutory commission that I'm on, in which we spend a great deal of time previewing, exchanging by email proposed legislative testimony and reports. It seems to me that there might be a middle ground. I mean, I feel a responsibility as a commissioner to see at least what the testimony that's being submitted and what the recommendation is. I would think it could be circulated at least at the time that it's submitted. I don't think that happens. It's sort of in the monthly report, and I read the ones that you gave us. Couldn't they be sent to us by email at the time that they're submitted?
They definitely
So at
could.
least we have a heads up as to what our
Yeah.
position is.
Yeah, absolutely, we can do that. I will say that you cannot conduct business by email. We can inform you of things, but you can't email back and say, I have a problem with this, or can we talk about this? Because that's the commission conducting business, which cannot happen other than in the public. So we can send you information, but we cannot discuss it by email. We can only do business. You can only do business in this setting.
And that applies to whatever. Why doesn't that apply to my other?
Yeah,
commission?
I'm not going to comment on that, but
that applies to things that go off with a short fuse, which is most of them happen. You know, the introduction and the scheduling of hearings and stuff like that. But some bills are there in advance, and you might have an opportunity to get a heads up in executive session at a next meeting before scheduled here. I don't know how that would work. But
I'm totally open to discussion, as I know Barbara is, about how we want your input, how we can practically make that happen.
Yeah.
Because honestly, most hearings, there isn't a month. In almost any committee, between the time that the bill is introduced and there's a hearing, it's not a month.
what are you focused on about business? I mean, if an email goes to all the commissioners and all the commissioners are in.
If what you're asking about is to approve the testimony and the commission's decision, you cannot do that by, because it's a secret meeting and it violates the Freedom of Access Act. You cannot meet except when a quorum is present in public, which means you cannot conduct business otherwise.
We can inform you of things, but you cannot take action.
So, I mean, if you want to see it as it goes in, that's easy enough.
Yep.
But if you want to approve it, A, that is a complete sea change in how we operate. And B, logistically, it's nearly impossible. I don't necessarily want to talk about the sea change in how we operate here because it involves legalities, and we should do that in executive session when we talk about the rights and duties of the commission. But as far as process, I mean, Amy and or me and or Kit are often writing testimony the night before the bill is going to be heard, because that's when we find out about it. That's when a legislator calls and asks us about it.
And part of our mandate is to, within the statutory mission, is to give information to the legislature, to provide advice about executive action.
Oh, yeah, we certainly want to weigh in.
And so, she's right, sometimes we're drafting testimony the morning of, we're drafting testimony on one bill while we're sitting there at a hearing for another bill. So the sea change question is one that I think is fair to talk about, because it goes back to far before me. This is the structure of the agency. It has always been the division of the understanding of the purpose. I think Pat Ryan, who was here for 40 years, that was her understanding. That was the historical understanding of how the agency, the volunteers, how they operated, was in having their executive secretary deliver that. But I completely understand your point, is you don't want to find out what your position is
Right.
a month later. That's a fair point. And we could talk about how to make sure you get the information more timely, but I think that is a different question than being able to weigh in on what it should be.
And that, I think, is my question, when legislator asked me. Not that I didn't know about it, because but that, do we agree on it? Do we vote on it? I mean, some are very, I think some are very fine. And neither for nor against, just giving information is great, but against or for something. I get it, the logistics. I don't know how that would work. Because I do know how fast it works, so it goes up there, and I do know how busy everyone in the office is. I just threw that out there and kind of put a wrench on things, sorry.
No, it's,
But you can also just point out that it's a little uncomfortable to have people coming up to individual members of the commission to ask about the commission's position on something, because your individual position is utterly irrelevant to the commission's position.
Okay, that's a basic question. I mean, that's important.
I mean, and I don't mean to say it's irrelevant.
No, but I
Obviously
don't-
we care, but there's plenty of case law that talks about how the individual position of one board member does not have anything to do really with what the position of the board is. So for someone to be asking you about whether you agree with the commission's position is.
No, not that but that the commission, was against this bill. Okay, so it wasn't what do you think about it? It was how was that determined? So we don't need, I know we're beyond time, but New Ed said something about it last month, and then when I got a question about it, it just kind of.
and we're not trying to shut down conversation.
No, I
These are
know.
fair topics to talk about. So the purpose of the agency and how it operates, that's
Yeah,
all
absolutely.
very reasonable for us to talk about. I do think maybe there's one other matter that, if we could put a pin in that, I think
Yes.
maybe we could do our cases and then come back to it.
Yes.
But I forgot to mention, that we had a request for a new investigation. I think you have this printed in front of you. This was a complainant whose case was decided at the April meeting, and they did not appear. And they have presented, all the attachments are their pleadings, asking for extensions of time. Because they allege that I was biased against them, even though they didn't meet the criteria for presenting a request for a new investigation, Barbara and I decided the safest approach would be to give it to you and let you address it.
Do we need to address this now?
You can do it, you can when we come back into open session after executive session, you can
Yeah,
vote on it.
Let's do that. Let's do that.
Okay, so we'll put a pin in that. We have several pins. And we'll come back to that.
Are they colored?
They are different colors.
All right, well, we're well past 8:45. So the remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I'll ask that you introduce yourself as you, well, if you're physically here, as you come to the podium or as you are identified on Zoom. Let me grab my agenda, which I enter my passcode every time on. It's Ahern, correct? Is that the next case?
Yeah.
Yeah, and I will say we're getting we have some messages from people saying that some people are having trouble getting in.
Mark is here. I took care
We
of it.
have some others, like I responded in the first case too. Five Mark is here.
There are a lot of people by phone too.
Mark was the only record I got.
I'll at least identify our first
Yes,
case.
thank
It is H22-0380A through K. Linda Athern or Athern, I'm so sorry, versus Melissa Martinez et al. And this is a no reasonable grounds case. So when we're finally ready, we'll hear from representative of the complainant or her representative.
I think it's okay to go ahead. One of the respondents who can I just ask, Mr. Franco, do you represent Melissa Martinez?
Yes.
Okay, so that's one of the people who was having trouble getting in. So I think it's okay to go ahead.
Yep.
All right, thank you, Commissioner Ashby. I think we're all set.
All right, thank you, Mr. Franco, please. Yes, Mr. Franco, please.
And we have actually complainant Linda Ethern, and I also am sure that I have butchered your name and I apologize for that. Since there's no reasonable grounds case, you would go first. You will have 10 minutes to present your position. Could you unmute yourself, Ms. Ethern?
Mute Mark again, yes.
So there's no attorney for complainant.
Correct.
Just complainant.
Correct. Okay, Ms. Ethern, I would just ask you not to mention the names of any individuals unless they are respondent. Okay?
Yes, I hear you.
Okay, so go ahead. You have 10 minutes.
Well, I mean, what can I talk about? I mean, maybe the whole thing?
It's up to you.
Oh, fine. Well, I moved in McGunner Cookhouse in September. And from the day I moved there, I had nothing but problems for people, discrimination against me and my service dog. And the problem still continues today with me and my service dog. Since I filed a suit against these people, I've had nothing but harassments, insulted, and everything else. And now my living arrangements are going to be lost because of these people, or retaliation, I call it. And I don't think it's right, what's been going on to me. You people did an investigation, and I read all the letters that the people wrote about me, every one of them. And most of those letters were nothing but lies. And management's in with these people. That management doesn't run that place. It's 9 group of people that I filed a complaint against that run that place over there. And it's not fair how I've been treated. And I did not, and I will not agree with the investigation that you had about those people. You blame me. I'm the person that's been blamed here, and it's nothing but lies. And I think I've taken a lot from the management and the people there. That's all I have to say. Thank you.
Okay. Now I'm going to see if our commissioners have any questions for you. Commissioner questions for Ms. Athern. I don't see any just yet. Now, let me just say that this afternoon you will have about 8.5 minutes left after we hear from the respondents, if you want to add anything else. Okay? I'm gonna mute you. Oh, did you want to say something? No? Okay. So then we're gonna turn to Mr. Franco. Mr. Franco, can you let us know if there are any respondents that you do not represent here?
Yes, I don't, I only represent the individuals who are employed by Reality Resources Management. And I actually don't represent most of the respondents. Many of them responded on their own. Just trying to, I do represent Linda Martinez. And let me see here.
Melissa Martinez?
Melissa, yes, Melissa Martinez.
And the entity that you just mentioned is not a party to this case? Did you mean McGuntacook Housing Associates?
I'm sorry, Reality Resources Management,
They
Management,
are
yeah.
not a party to this case.
Let me see here.
I think they might be employed by that entity, but that entity is not named.
I represent Melissa Martinez, Teresa McDonald, and McGuncook Housing Associate LP.
Okay, great.
Yes,
You're
So-
presenting on behalf of them. Go ahead.
yes, thank you. So I'll actually be as brief as I've ever been in my career, and that is that this has been the subject of a very extensive investigation. It's been the subject of a lot of providing of a lot of information to the commission. There have been supplemental requests, supplemental responses. We've provided a lot of documents showing the responses that my clients have made to the complainant's complaints. They've been very respectful of her. They're sympathetic to her concerns. They've conducted investigation into her complaints. They've done interviews. They followed the protocols. And suffice it to say that this is a matter where there are complaints being made by the complainant, and there are actually complaints being made by many of the respondents against the complainant. And the only thing that my client can do is basically do an investigation, and they can take affirmative action against individuals if they feel as though those individuals have violated any of the policies or violated the laws, but they've concluded that they have not. The investigator concluded that the complainant had failed to establish a claim that my clients have subjected her to a hostile work housing environment, et cetera. And also that the investigator found affirmatively that we took immediate and appropriate corrective action in response to the complaint. And that's all set forth on the bottom of page 3 of the report. So we would respectfully request that the investigator's report of no reasonable grounds with respect to Melissa Martinez, Teresa McDonald, and McGuncook Housing Associate LP be affirmed by the commission. I'm happy to answer any questions.
Thank you. Any questions from commissioners for Melissa Martinez, Teresa McDonald, or McGuntacook Housing Associates? Mr. David?
Could you just review, tip off for me briefly the actions that they did take in response to the complaint?
Yes, let me just refer to my supplemental response. And we provided several exhibits to the supplemental response as well. But basically, it was almost it was a recurrent theme, if you will, that she was making complaints against the basically her co-tenants. And if you review my supplemental response on February 14th, 2023, it identifies the dates that complaints were received and what the manager's response was. And if you'd like me, I could go down through each of the complaints, but they basically, they were in, they started way back in September of 2022. Tenant meetings were taking place, were scheduled, memos were sent to tenants in follow-up to each of the meetings. Individuals were talked to about the complaints. There were so many meetings and so many memos that it's very difficult to categorize them all, except that they're all attached as exhibits to our response. Ms. Martinez did most of the investigation in response to Ms. Ahern's complaints. She spoke to each of the individuals that were identified. She had meetings with Ms. Ahern about each of the issues. There was also an issue about, an open parking space that was addressed. Again, there was also an issue about her not wanting to park under a parking space where there were trees over it. And our response was that, we had trimmed the trees. I guess she was concerned about the trees falling on her car or something like that. So anyways, we even put placards on parking spaces for her. So really, management really went beyond the call, if you will, with respect to each of the complaints here. And frankly, she's taking up so much of the management's time. They're having a difficult time servicing the rest of their tenants because of the amount of time they're spending with Mrs. Ahern. So there seems to be some personality conflicts between her and her co-tenants. That's unfortunate, but this is not a case of discrimination or harassment or hostile housing.
Any other questions for Mr. Franco at this time? Seeing none, thank you. And I'm gonna see if the other respondents who are not represented by Mr. Franco are here. There's a lot of folks here on the phone, so if you are here on the phone, if you can unmute when I call for you, then we'll be able to hear from you. We want to make sure we can hear from you. Karen Nolan. I'm going to call each of these names, and if you can unmute yourself, then we want to make sure we get to hear from you. Karen Nolan, Joanne Miller, Ramona Benner, Nina Lones, Jeannie Sparhawk, Mary Paulson, Alice Berry, Kevin Walsh. If any of you are here, please unmute yourself so we can hear from you. Or if you're here in the room, I don't think you are, but I know we're getting messages that some folks are saying that they're stuck in a Zoom waiting room and we don't see them on here. Oh, there's one of them. Okay. So it may be that there are other folks who are in waiting. So do we have any of the folks from Karen Nolan, Joanne Miller, Ramona Benner, Nina Mons, Jeannie Sparhawk, Mary Paulson, Alice Berry, or Kevin Walsh? If you're here, unmute yourself if you want to be heard. So I don't see any of those folks. I don't hear any of those folks. So for now, I'm going to turn back to Ms. Ahern. Ms. Ahern, you have a little over 8 minutes if you want to rebut anything that Mr. Franco said. You have to unmute yourself though.
Yeah, I'd like to make comments on what the lawyer said. This case has taken up so much time. If it's taken up so much time, how come this is still going on at the building? And secondly, I had a doctor's note to say about where I could park, and I did not ask to be parked where I am parking today. I gave Terry McDonald a doctor's notice saying that I could only walk so far. And what did they do? they turn around and make other accusations about it, okay? So, no, I don't agree with what the lawyer said. This is all hearsay, thearsay. Where's all this evidence that they're supposed to be here against me? Where's all the evidence? I'd like to see. It's all my fault for everything, and I will not take responsibility for it. The letters were all lies. Some of the things that people said about me was nothing but retaliation, and he knows it. Their poor management. I'm almost going to lose my place because of these people, what they've done to me and still doing today. And you think that's right with a person with a disability and a service dog? No, I don't think so. This is going to end up in a civil suit. That's all I have to say. And thank you for your time.
Thank you. Any commissioner questions for Ms. Ether?
Thank you. I guess I do have a question. You've said a couple times that it looks like you're going to lose your housing. Are you saying that's in retaliation? How is it gonna
I'm
happen?
saying that in retaliation of what these people have done to me. I was away for a week. When I came back, I found a 7-day determination on my door. I was served with the eviction, and I'm still working on that today. I'm on probation for a month because of these people. These people have put me through hell. Pardon my language. They've made my life miserable. I've got psychiatric care and everything for what these people have done to me. And it's not right in my condition.
Thank you.
Mr. Douglas?
Yeah, I just wanted to follow up on that. Is there a basis for the 7-day notice of termination set forth in the notice? Are they telling you why they're kicking you out?
Yeah, this is a termination of a leash that I got in my door.
Yeah, but the question is why? Is there a
Because they
reason?
want to get rid of me. They want to evict me.
I'm not sure.
If I could interrupt for a minute, hold on. The notice of eviction, if it has occurred, is not part of this case. This case is about a hostile housing environment. And so anything that happened after that is actually not part of this case. It may well be that Ms. Athern will bring another case about an eviction, but that's not part of this case. Are there any questions about the hostile housing environment claim, which is an issue in this case? Commissioner, did you want to hear from Mr. Franco? Any follow-up from Mr. Franco? Mr. Franco, I think you have time if you want to. I forgot to come back to you, sorry.
I will state that management was aware of Ms. Athern's having an assisted animal. There are 5 tenants in that facility that have 6 assistive animals. So she's not the only one. There are other individuals who management is aware of who have various forms of disability, unfortunately. So, you know, this is a housing project or housing development that has a lot of people that have difficulties. So she's not the only one. And her co-tenants have very strong feelings about sort of her actions against them. I'm not judging Ms. Athern. You know, I'm sure that she feels as though she's not being treated appropriately. But all I can say is on behalf of my clients that they've responded to each and every one of her complaints. I think she wants my clients to evict everyone except for her. And that's just not going to be possible. If that's what she's looking for in terms of, you know, action. All we can do is address the complaints, do our investigation, and act appropriately. If my clients felt that there was any substantive basis to the complaints, they would take the actions that would be required of them under HUD and under the specific leases of the individuals. So they've done what they could for her, and unfortunately, it'll never be enough. Thank you.
Any commissioner questions for Mr. Franco, who's representing Melissa Martinez, Teresa McDonald, and Magenta Cook Housing Associates. And I'll just call one more time for the respondents who we don't have here: Karen Nolan, Joanne Miller, nope. Yep, Joanne Miller, Ramona Benner, Nina Lonas, Jeannie Sparhawk, Mary Paulson, Alice Berry, and Kevin Walsh. If any of you are here and you want to be heard, please unmute yourself. So I'm not seeing any of those folks. So commissioners, at this time you've heard from complainant, you've heard from 3 of the respondents. The other respondents do not appear to be present. And in terms of hearing from the investigator, I will say that originally this was from Courtney Byrne, who has left the agency, and then last month Jane O'Reilly was going to present it, but now she's on leave. So Kit Thompson-Crossman, who is familiar with the record, is
Very limited information for you. Just say I have nothing further to add. If you have any questions, I will do my best to answer them, and I will rely on Barbara. So.
I'm sorry that our familiarity that's gone from investigator to investigator. That's not totally unusual, but yeah.
Question for Barbara. And if you've done this before, I apologize. The fact that 3 of these respondents we heard from counsel, how do we deal with the rest? Meaning, do you know what I'm trying to say? I mean, they don't show, so do we just?
No, they aren't required to have participated because the report found in their favor. So the burden remains on the complainant to prove to you that there are reasonable grounds.
Okay.
There's no presumption from their
No.
failure. to
Okay.
attend.
Okay.
There might have been from their failure if they had failed to participate in the investigation, but they did participate in the
Okay.
investigation.
Okay, thank you. Any questions about the investigation? Seeing none.
Thank you.
So commissioners, you heard from complainants and from at least some of the respondents and had an opportunity to ask about the investigation. And at this time, there is one proposed finding, and we will be looking for a motion. Commissioner David?
I move that we find that there's no reasonable grounds to believe that there was unlawful discrimination and the complaint should be dismissed.
Is there a second?
Second.
So commissioners, it's been moved and seconded to find no reasonable grounds to believe that the respondent discriminated against Linda A. Fairn on the basis of disability. Is there any discussion?
Well, in speaking to the motion, I'm convinced, and I had read the entire investigation, that the respondents did respond appropriately with meetings and notices and did the best they could in a difficult situation.
Any additional discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
So the findings are that there are no reasonable grounds to believe unlawful discrimination occurred. The commission will send all the parties and Mr. Franco a letter confirming the finding. And we appreciate everyone's participation, and especially since we did this a second time. So thank you all very much.
Next is MHRC number H22-0418, A, B, C, and D. This is Daryl Stubenrod, Daryl goes by Danielle or Danny, versus George McDonald, Tanya Boter, Jeffrey Baldwin, and Victoria Pease. This is a no reasonable grounds case, so we should hear from Ms. Stubenrod or her representative.
And I don't know if one of the folks on the phone in here is Ms. Stubenrod. Ms. Stubenrod, if you are present, please unmute yourself so that we can hear from you. And can we get Colin? Oh, Colin, do you see the email address or the phone number or anything for Ms. Stubenrod?
I do not.
Okay. Ms. Stubenrod, if you are present, please unmute yourself so we can hear from you. Mr. Libby, I appreciate you being here.
You're welcome.
Oh, there's Colin. Hi, Colin. So we have not, they're checking the voicemails at the office to make sure that anyone who's having trouble logging on is heard from. We have not gotten anything like that from Ms. Stubenrod.
And this was the one that,
This was postponed at the last meeting at Ms. Stubenrod's request.
Right.
So without Ms. Stubenrod present, typically if the party who opposes the recommended determination is not, typically the commission votes to adopt the recommended finding without hearing from the investigator. That's the typical process. If you want to do something other than that, that is up to you. Commissioner.
No, I'm ready to make a motion.
Okay.
The motion would be, we find that there's no reasonable grounds to believe that there were respondents unlawfully discriminated, and the complaint should be dismissed. Maybe that's not the language for it.
Oh, no, that's correct.
Second.
I'm sorry, who is that? Jeff. No, you're fine on the language. So it's been moved and seconded to find that there are no reasonable grounds to believe that the respondents discriminated against complainant on the basis of sexual orientation or gender identity and to dismiss the complaint. Is there any discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
yes,
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
So the finding is no reasonable grounds, and the commission will send the parties and council a letter confirming that, and we appreciate you being there.
Great. Thank you, everybody.
Thank you.
Next is E21-0161. That's Pamela Prodan versus Franklin County. This is also a no reasonable grounds case. We should hear from the complainant or her representative.
Mr. Chair?
Yes.
Yes, I have a favorable interaction with the complainant. She's a colleague in the Franklin County Bar, and I've supported her election to the employment that brings her in contact with the respondent, so I will recuse myself.
So if you, Ed, if you wouldn't mind sitting over there, that's typically what.
Oh, okay.
Was we have the person who's recused not be seated.
Okay.
in there deliberating. Ring, so you have 10 minutes.
Thank you. I'm Susan Farnsworth, attorney for Pamela Prodan, who is sitting over here to my right. Pamela is the county treasurer, elected county treasurer in Franklin County. And we have a fairly voluminous file, and I do appreciate, especially after hearing how much work there is in front of this commission, that it's really hard for people to go through everything. So I just would like to focus on a couple of points. Kind of the what and the when of this case, because the issue we have is a disagreement over the why. In other words, the investigator decided that the commission, I'm sorry, no, yes, the Franklin County Commissioners had a valid reason for cutting my client's pay. And we would argue that that's not the case. And first, I would ask you to just keep in mind what they did was cut $10,000 from her pay. She was part-time and had a compensation package of $22,000 plus. So it was over 45% of her pay that was cut on June 30th, 2020. And I would like you to keep in mind that this is out of a budget of over $6 million. It's a budget for a county that employs, I'm not sure of this, I think it's over 70 people. And that's a lot of money in a budget to have to take $10,000 from a particular person's compensation package. Secondly, what they did was took that money for the purpose, they said, of funding a position in the clerk's office, not in the Treasury Department, although it was going to do part of the work there. But again, I guess I'm assuming that almost all of you would have had enough experience, or you wouldn't be here, in public life, that you've seen budgets, you've seen operations before, and it's highly unusual, it seems to me, to, when you're trying to fill a staff position, take it from another person's individual salary. And this is a salary for an elected official that the commissioners did have the power to set the budget. They did have the power to decide on. But that's why I would like you to also look at when they did this. When they did this in June 30th of 2020, they were doing it after having, in April of 2020, sent their regular budget proposal to the budget committee, as they're required to do by statute. They sent a regular budget proposal that proposed keeping the treasurer's salary and benefits the same as they had been, with a couple $100 difference that was kind of an across the board issue. I don't know what it was, but basically the salary stayed the same in their budget proposal that year in April. In May, Commissioner Webster of the County Commissioners expressly put in an email that is in the record that he was not intending to cut the treasurer's pay or benefits. This is also in a long line of there'd been an express written, there had been an express vote in 2018, right before she was elected to this term, that the commission said they were going to keep the treasurer, Pam Croda, if she was reelected, she would continue at the same salary and benefits.
I'm sorry to interrupt you. I'm so sorry, but I am seeing that Respondents Council is not able to get on Zoom. And I thought that they were here. And I'm so sorry to interrupt you, but I don't want you to get through the whole thing and have to do it again. I am so sorry. But I also need to make sure that they could hear your presentation.
Right.
We're having a lot of troubles with the Zoom this morning. A lot of people are saying they can't get into the waiting room, that they're waiting for us to let them in. Would you mind giving us a minute? I'm so sorry. It's terribly intrusive, and I feel terrible that I didn't realize this before now. Let me see if I can invite her. That's here. I think at a minimum, you're going to have to start again. And I'm sorry.
Hopefully I can remember what I said. Glad you caught it.
Yeah. Would that could have been worse. Would that I could have earlier. Just want to make sure we see Ms. Eggleston's page. Eggleston will be coming on.
Guess I could afford you one.
Oh,
Probably silly.
You don't see her yet. Do you want to sit down for a minute? I
Well, if it's gonna be a minute,
I honestly can't tell you how long it will be. I'm doing my best to get her in here, but
Is she trying to get on? That'd be interesting.
people are saying that they've already seen explanations like I'm sitting in the waiting room and I'm waiting for you to approve me and they don't show up for us. Or they say the link doesn't work, but if you put in the meeting code or the email number, that works. But all the other people here have managed to get here, so I'm unclear what the problem is.
okay.
And the next case is sitting in the waiting room. Yeah, there's a feature to turn on the waiting room. Do you want me to try that? Maybe they'll just pop in without. Let's try it. I couldn't get to that from It's our ability to keep other folks out, but we can want to take that. Someone? He says they're clicking on the link to the meeting.
I just emailed her the same link I emailed Mark. She said it says the post will let you in soon, so I told her to try leaving and coming back. Since we turn the waiting room up.
Maybe they could call it. She said she's watching it on the YouTube live stream, but if she could call in. She could participate. Like, not have this much trouble with Zoom. Wow.
Future hosts, do you want to try to log out and log back in? And maybe the feature doesn't activate until, oh, someone just got up.
Thank you.
Oh, she go. There, now she's gone. Must be something to do with Zoom. Or maybe the Wi-Fi. There she is. Okay, we have responded.
Log out and log back in, and maybe the feature doesn't activate.
Okay, so if you have your volume on there, okay. Could you, Ms. Eggleston, can you keep your mic off? Okay. I apologize to everybody. Clearly, I have no control over this. And I really apologize to complainants counsel who has to start all over again. But I think, do we have Bob? We have the investigator, we have complainants counsel, and we have respondents counsel. So now let's try again. Thank you so much, and I apologize. Ms. Farnsworth.
This is Susan Farnsworth again, and I represent Pamela Proden, who is the elected county treasurer for Franklin County. And there was a fairly voluminous record in this case, which I understand is difficult for the commissions to deal with just because of the volume of cases you have. So I just want to highlight a couple of facts and make a few points to explain why we disagree with the conclusion that the investigator reached, that when he asserted that we hadn't met a burden of showing why that her cut in pay was due to the report that she made that her office was out of compliance physically with the 6 foot spacing distances and the basic COVID prevention measures that were required at that time. So I would like to talk first about the what of what was done. And what was done on June 30th, 2020 was to cut $10,000 basically from her compensation package, specifically from the treasurer's compensation. And this is part of a budget that's over $6 million. And it was cut ostensibly because the clerk of the county had said, actually for a few months, that she needed another staff person part-time and needed another $10,000 for that. There was some dispute at different points about whether or not it had anything to do with the treasurer. But the point was that they were taking money from a particular person's salary and compensation to fund another position that was primarily for a different even department, for the clerk's office. I would submit that just in general terms, I guess it's like asking the commission to take the equivalent of judicial notice, that it is highly unusual in the budget process to do it that way, especially $10,000 out of $6 million. And it also brings me to point out sort of the when this was done, what the timeline and what the history was of doing that kind of thing. First of all, the county commission had expressed in prior places that are in the record that they did not generally cut payer benefits for elected public officials during their term of office. This was during a term of office. Secondly, in this case in particular, with reference to the treasurer's pay and benefits had come up in the past, And in 2018, before the election that was for the term that we have, and there's an exhibit to this effect, the same commission, same people, and same county commission voted specifically that if she were reelected, she would continue at the same pay and benefits. So there was that history as a backdrop. In 2020, the budget had to be submitted 60 days before the end of the fiscal year. Fiscal year ended on June 30th. So on April 20th, and this is in the record, the commission submitted a budget to the Franklin County Budget Advisory Committee. In that budget, they had the treasurer's pay and benefits at the same level they had been, with a couple $100 difference, but that was an issue that was unrelated. So basically, the commission had started this process with adherence to its previous position that there wouldn't be any change in the county commissioner's funding of her position. Secondly, they had voted not to increase COLA or not to provide a COLA increase for the treasurer in another position in that same window from between April and June, but they didn't make any mention of cutting. They just decided not to give her 0% for COLA. Thirdly, on May 11th, I believe, May 15th, I'm sorry, there's an email in the respondents package that has Commissioner Webster specifically affirming that he is not intending to cut the treasurer's pay or benefits after a discussion they'd had earlier. So there was absolutely no indication that there was interest in cutting her pay and benefits going into this budget session. There were things in writing confirming that. So the next thing that happened was on June 16th, when she was making a presentation to the county commission about her department as part of this budget process. She started by explaining the measures that she had taken in her department to meet the COVID prevention requirements in the governor's executive order. And she explained that she had implemented staggered work hours, remote working, and that things were going actually even better than they had before. They were doing everything they had to do. And during that meeting, the commissioners kept repeating, but you're not coming in, you're not coming in. And if you're not going to come in and we have to come up with more money for the clerk's office, then we're going to have to look at your salary. So I would offer that although it sounds innocuous, that is right there an admission on the part of the commission that they actually were going after her salary because she was the one that wasn't willing to play ball with what they wanted to cover for the clerk's office. And really, it wasn't part of her job, it was part of her duties. It was something they did as a courtesy, but it had stopped even before that. So they said, I don't care what it is. They said, whatever was one of the words they used, whatever the reason, whatever your choice is not to come in, it doesn't matter. If you're not coming in as part of the reason why we have to have another person, then we have to look at your salary. And it's, as I say, it seems innocuous, but I would also ask you to think about when this was taking place. It was taking place during the height of the early part of the pandemic. So this is a huge issue. One of Pam's exhibits in response to, in the very beginning of this case, response to the respondent's reply, I showed a little calculation she did from reading the national and international coverage of COVID in February. She had calculated that they were saying COVID had 60 times more the mortality rate than flu in an average winter season. That's what the numbers were on the side of her page register there. She took this very seriously, and she, as later explained to the commission, was virus herself for COVID, and so was one of her employees for health reasons. So it was a volatile situation for personally very serious for her employees, and in that day and time especially, when somebody says, I don't care, I don't really, it doesn't really matter, I don't know why you're not coming in that context, it's kind of rude or disregarding and kind of saying, we don't really care what anybody says about this COVID thing. We don't care. You should be coming in. So that's the context, and it's hard to go back there. Granted, we're all wearing masks today, but it was much more heightened in those days. So June 16th, she made that presentation. They said, well, we're looking at your salary. And June 30th, they cut her salary 45%, ostensibly to cover this other position. But at that time, as was noted in one of the filings with the investigators report, they already knew that she had agreed to come into a different room that they provided. So it wasn't about that. The only reason left out of their ostensible reasons was that she was not going to answer the phone. She hadn't been answering the phone for quite some time, and it wasn't her job to answer the phone for general public inquiries, like, who do I talk to about something? So basically, to cut $10,000 out of her compensation package because she wouldn't answer the phone once in a while is wildly disproportionate to what it was. It was really didn't make sense. And it was, well, the only thing that had happened since they submitted the budget and since they said, oh, we're not going to cut your pay, was this report about COVID. And we believe that it really was very clear in the record and at the time that this was, they were just not happy with her taking this so seriously and acting that way. So for those reasons, we would ask the commission to overturn the investigators' conclusion that there are no reasonable grounds. Are there any questions? Yeah.
So hello, Attorney Barter, by the way. So when your client did in fact return to work, admittedly not answering the phones, her salary was in fact restored though, correct? Her entire salary was restored. She was, ultimately the commission made a decision not to provide her the benefits that she had previously had. But she was actually, you mentioned the $10,000 figure, she was actually restored some $6,000 in salary, is that correct?
They said they didn't really care what she applied it to. They did end up applying it to salary, so the answer is yes. However, their personnel policies expressly state, it's on page 21 of the exhibit that the respondents put in, that the commissioners and the treasurer shall have 35% prorated flex benefits. And they just disregarded that. So yes, it's true that they restored her salary, but that's when your salary is that level, the benefits are a big deal. That's a choice of how to invest them, but it's part of the compensation package. So they went out of their way to do that.
And the record is correct that the commissioner, at least one commissioner stated that that person didn't feel that they had wanted to give a person who worked 13 hours a week benefits, right? I mean, you may argue that it's pretextual or something to that effect, but that was the stated reason, correct, for not restoring the actual benefits, was that they did.
They've had that attitude to some extent since 2018 when they voted to do it anyway, to give that. They've had it since it's been in the personnel policy in writing. They've had it since Commissioner Webster said we're not gonna touch this. So yeah, they had that attitude, but why did they override all of their precedent and their own rules at that time? That's our point. There's only one thing that happened in the meantime, and that was this discussion about COVID compliance.
Well, one might argue that what happened was that she refused to come in. They wanted her to come in. They then reduced her salary because they believed she needed to be replaced by someone. And it's easy to take away, but when you're asked to then give it back, that's when you can be petulant, or you can fulfill your long held wish to not give these benefits to part-time employees? In other words, couldn't it be argued that it's not in fact pretextual at all, but that's something that they've been maybe waiting for an opportunity to do for some time, and this, your client's behavior provided them that opportunity?
Well, if the behavior was just sort of a secretary who didn't want to come in, that might be an argument.
Right.
This is not just a secretary, this is a treasurer or the town who's an elected official. And they don't, they respect that and they respected it in their rules, so that the rules provided expressly that they were going to do this. They didn't even touch their rules, they didn't change them. Secondly, they were treating her. I mean, I've got, as I was preparing for this, this could have probably been a sex discrimination case. I don't know whether it would have been any better off, but I just think if she's been a man, they would not have been saying, oh, because you won't answer the phone, we're going to do this to you. But even if they did, that's not the way you do it, is to take somebody's salary and cut it in half. She didn't answer the phone all the time. The days they're talking about are the days that they put the county payroll out. A busy time. And I guess the other thing generally is that they weren't saying, you aren't coming in. They were saying it doesn't matter why you don't come in, but it did. And it would. If she wasn't coming in because she was concerned about her health, because she couldn't go in and work without being exposed to other people, be 6 feet away, or having the public come in. It was not a safe environment. So she was coming in, but not during work hours. So that was their concern. They said it doesn't matter, but our point was that that's an illegal reason if the reason she was saying she had to do it that way with staggered work hours was to comply with their own policies that adopted the governor's COVID prevention policies. In other words, you can say, I don't want you to do something, but if your reason is race, you can't do it. If your reason is sex discrimination, you can't do it. In this case, if your reason is because you're telling us that it would be violating health conditions in your workplace, then they can't do that either.
This is neither a whistleblower case nor a reasonable accommodation case, though, is it? I mean, she didn't ask for an accommodation to not come in. And she certainly isn't claiming today that she was treated the way she was because she was complaining that they weren't in compliance with the COVID rules.
She did say that their office was out of compliance with COVID rules in that report on June 16th. And it's true that what she was saying was, I found a way to deal with it, and it was by staggered work hours and remote working, which was recommended actually in both the executive order and the commissioner's own policies at one point, but they just didn't like it.
So what evidence is in the record that they just didn't like it? I understand your argument is in part due to the timing, right? I mean, it's the proximity and time response.
Right.
But what evidence is in the record that commissioners were unhappy with what was happening regarding COVID in the office?
I would just say, when they say, I don't understand why you're not coming in. I don't care why you're not coming in. Whatever your choice is for not coming in, it doesn't matter. If it's going to cost us money, we have to replace you. That's in the record from that meeting. So they said, we don't care about that. And I think even in the fact finding, the commissioner said, we never checked the space between the desks. We don't really care about that. I didn't even think the building ought to be closed anyway. They just was an attitude.
Thank you so much.
Yeah.
I just want to understand the timeline on the benefit situation, right? So she's selected as the treasurer, right? She's going to get a certain salary and a certain benefit package, right? And pursuant to her position. Right. She decides she's going to work out of the office for a while. They cut her salary. They reinstate her salary when she comes back to the office to work full time, but they decline to restore her benefits. Am I correct so far?
Yes, although I would say they didn't just cut her salary, they cut her compensation package. They didn't specify.
Right. Okay. So when and I just want to make sure I have this right. So when she comes back to the office, right, and when she says, all right, I'm gonna go ahead and work the hours that people wanted me to. Those are the same hours that everybody expected her to work, right? When she was elected treasurer, she was expected to work a certain amount of hours.
No, I would not agree with that.
Okay.
I think she's a salaried position. She had an average number during a period of time which she's talked about, but sometimes it was more when they were doing audits and things like that. Sometimes it might be slightly less. But she wasn't on the clock. It wasn't an hourly paid thing. It was a salary position. And her position to the commission on June 16th and subsequently was she worked no fewer hours. She worked the same hours. She just was working remotely.
Right.
And they kept saying, but you're not coming in, you're not coming in. And then when they did know that she was going to come in and work in another room, they said, well, you're costing us money because you won't answer the phone. But so we're going to just go ahead and do this.
Right. So she was working, once she comes back to work, she's basically working the same hours that were contemplated under the salary arrangement. Do you agree with that statement?
I don't think the salary arrangement is related to hours. It's a salary arrangement. It's just a number.
Okay.
And the commissioners were able to adjust that, but she's acknowledged that, the investigator acknowledged that she acknowledged that they have the power, but if they exercise it for an illegal reason, then they don't have that power. So that's what we're saying. And I think it's that, there are only 4 or 5 elected officials in the county government, or maybe that's maybe 6 or 7, I'm not sure. And for one of them to speak up and say, my department needs these protections and we need to work remotely and staggered and we're not hurting anybody else that in terms of our functions and we're doing our job. If they get their salary, as opposed to even their department cut, by over 45%, that is a huge thing. It's clearly a chilling effect. Nobody else better try this. So I think that's why, as far as we're concerned, June 30th matters. That's the date they decided it. Whatever they've done since then is really, it mitigates some of the things that was done, but it doesn't change what they did. Was flat out just reacted by saying, you're cutting your pay. That's, to me, is an extraordinary thing to do.
I'm gonna take one more run at it. So I was thinking, am I gonna try, put it one more time? I think we're missing each other a little.
Oh.
What I'm trying to get at is that once she comes back to work, right? I mean, in the employment context, I hear what you're saying about the salary and the numbers, right? But in the employment context, when you say I'm going to pay somebody a salary, right? There's certain expectations as to how available they're going to be, the job that they're going to do, and all this sort of stuff. Once she comes back to work, right? She says, I'm back. I'm gonna do, I'm gonna be around. I'm gonna do what needs to be done. Was there any dispute in your view in terms of whether or not she was within this accepted range
Of what?
of the time she was working, the availability that she had, the duties that she was performing?
She never was not within that range. She didn't come back to work. She came back into the office during working hours. She was coming into the office, but not during working hours before. And she was working the same number of hours from home. So she never stopped working. She never stopped hours. She didn't stop the frequency. They got the payroll out. They did what they needed to do. So she never stopped anything.
Right, and that's my point. So she never stopped. She's working the entire time. The dispute is that she's not coming into work. She's not doing it the way they want it done.
Yes, except that they knew on January 30th during that meeting, she said, I'm going to try what you suggested and I'll come back and I'll work in the commissioner's room because they're not there. So at the time they cut it, they actually knew she already had a plan to come in and work in the office. So the only thing that had been raised was that she had said, and it was actually some months earlier, that she wasn't enjoying, it was too much of a distraction to be answering phones for every once in a while. It wasn't all the time. For the commissioners, for the clerk's office, was not even her department. It's like we work in the next room, so sure, I'll answer the phone. I'll talk to somebody if they wander in my door. It wasn't a really major part of her job at all. It had nothing to do with why they cut $10,000. Am I hearing you now?
You know what? I think we're still missing each other, but yet you answered my question nonetheless.
Oh,
Thank you very much.
Any other commissioner questions or anything else? Amen. Thank you.
Thank you.
And we turn to respondents council.
Good morning. Thank you. And thank you everyone for your patience. I recognize that was a frustrating start. But good morning, commissioners. My name is Paige Eggleston, and I am representing respondent Franklin County today. In this case, complainant has alleged whistleblower retaliation, specifically that a change in compensation was the result of having engaged in an alleged protected activity. A complainant's claim requires that she establish evidence that she engaged in a protected activity, that she was the subject of an adverse employment action, and that a causal connection exists between the two. Respondent is then required to demonstrate evidence of a non-discriminatory reason for the alleged adverse employment action. Respondent agrees with the outcome of the investigator's report and the investigator's finding that complainant has not met her burden here. Specifically, that she has not demonstrated that the alleged adverse employment action was related to her alleged protected activity. Factually, complainant was elected as the Franklin County Treasurer in 2014 and re-elected to a second term in 2019. She worked approximately 13 hours per week in the office, and her compensation, which was a combined salary and benefits, totaled approximately $22,452. One of complainant's job functions included the performance of general office duties and interacting with the public. In late March, early April 2020, complainant stopped reporting to the office for work during normal business hours at her office within the county administration building. That's a front-facing area. And she expressed concerns to the Franklin County clerk regarding the ability to maintain safe social distancing in the office. On approximately April 20th, 2020, the budget process began for Franklin County. And during that process, the county clerk articulated that she would reach out to the complainant to discuss complainant's salary, which would be discussed in depth by the board at their June meeting. And prior to complainants having conducted an alleged protected activity, the county clerk articulated that the county would need to find an additional $10,000 in the budget in order to provide full office coverage. This requirement for additional funding was a direct result of complainant no longer working in the office in that front-facing area previously described, performing general office duties and interacting with the public. On June 5th, 2020, the commissioners voted to add $10,000 into the budget for additional staff needed to cover public-facing offices. Complainant alleges that she engaged in a protected activity on June 16th, 2020, when she articulated to the commissioners that she had taken steps to ensure compliance with COVID guidelines. It was reiterated at this same meeting that $10,000 in additional funding had been previously requested in order to achieve necessary office coverage. On June 30th, the commissioners made the determination to reduce complainant's salary by $10,000 instead of raising taxes in order to have enough funds to hire additional staff to maintain office coverage. In mid-August 2020, respondent found that they only needed $6,000 in order to ensure office coverage. And because $12,000 had been budgeted for the additional coverage through the year, the remaining $6,000 was added back into complainant's salary. Thus, complainant's compensation increased to $18,000. And the commissioners made the determination not to restore complainant's benefits package, given the commissioners had the discretion to do so pursuant to their policies, and because some commissioners expressed disapproval with providing health benefits to an employee who worked 13 hours per week. It is dispositive here that complainant's change in compensation was solely based on respondents' need to fund additional staff time to provide necessary office coverage in complainant's absence, and completely unrelated to the alleged protected activity that she articulated. Although complainant argues these tasks are not a part of her job responsibilities, it was a function that she had previously performed since her election in 2015, and it had become a part of the regular operation of the county's administrative office. And as complainant acknowledged, respondent has the discretion and authority to change benefit allocations to employees. That's precisely what was done here, and as the investigator properly found, respondent's actions are wholly unrelated to an alleged protected activity taken by complainant. A couple of points I hope to just raise briefly. To the extent that there was no discussion regarding this change in compensation before June 30th, That's simply not accurate. There was an additional need for $10,000, and it was discussed well before June 30th and well before June 16th, when a complainant alleged engaging in a protected activity. There was a change in office functions here. That the change was that complainant had assumed office-related responsibilities, and as a result of changing her time working in the office, she was no longer performing those tasks that she had previously performed. And additionally, complainant's actions were not met with resistance. The record demonstrates that complainant was offered an accommodation on June 16th, 2020 to work in the commissioner's meeting room, well after she had articulated that she would be changing her work hours to not work during work hours and to work at a different time. And that was an accommodation that complainant articulated she was appreciative of. She was also not prevented from taking any of the actions that she took or the changes that she made. At this point, I am happy to take any questions.
Thank you. Commissioner O'Brien?
Thank you. Did I understand you to say that there is a job description? Is there a job description?
There is not. There is not a formal job description. And so when the commissioners were evaluating the complainant's salary, they considered on a fact-specific basis the work that she does. So that there's a statutory obligation there. And then there's the work that she does on a daily basis when she comes into work. And so all of those factors were used in determining what her compensation would be.
And general office duties, I think that's the term you used. Is that just, and that's because she had been doing it? Or, I mean, is that what you're?
Yes. So the record articulates that when complainant was elected to treasurer, she wanted to be a working treasurer and interact with the public. Physically, her office is in an administrative building. And so when individuals are coming into the office, when individuals are calling, her office is in physical proximity to those activities. And she had taken on that role at the start of her first term. And it is a responsibility that she had taken on for a period of years following. At the point where she had decided that she would no longer be coming into the office during normal work hours, that change in her schedule created a need for additional support in the office.
Thank you.
Sure.
The other questioner.
Yeah, on the benefits piece of it, I mean, I understand that the commissioners have the authority to reduce her benefits. I get that. But I'm a little troubled by the timeline. I mean, you know, what compliance counsel says is that her client was basically working the same hours the entire time, either in the office, outside of the office. Everybody knew, I guess, what her status was, whatever they considered it to be, part-time or what have you. So the timeline is a little troubling. Why cut the benefits at that point? Can you speak to that for me, please?
Sure. So I recognize the complainants council articulated the county's personnel policy. I would like to draw attention to where the definition of elected position is in the personnel policy. It expressly provides that the commissioners will decide the appropriateness of benefits for the position, as you alluded to already in your question. At the point where the commissioners had made the determination to reallocate $6,000 back into complainant's salary, they also determined whether or not they would reinstate benefits. And in that conversation, a number of commissioners articulated disapproval with providing this type of benefit to an individual who's only working an average of 13 hours a week. While it is a benefit that was previously provided, the sitting commissioners who made the determination not to continue to provide that benefit or reinstate it in this case, they were not the same individuals who had provided that benefit to complainant in the first place. Ultimately, as they discussed whether or not they wanted to provide the benefit, it was dispositive that because the complainant was only working about 13 hours a week, they did not approve of continuing to provide that benefit under the circumstances.
Thank you.
Any other commissioner questions for respondent? Seeing none, complainant actually used all their time at the beginning. So unless you want to add something, Ms. Eggleston, I think we're turning to the investigator.
All set, thank you.
Okay. So, Mr. Beauchene.
Good morning, commissioners. Thank you for your attention here today. Just to cover a couple of points. I would point out that the subject of the clerk requesting the additional $10,000 for increased office coverage actually predated complainant's alleged sole act of whistleblowing by almost 6 weeks. So the need was there prior to any protected activity. The clerk stated at multiple board meetings that the reason for this additional office coverage was a direct result of complainant essentially no longer agreeing to cover general office duties that she had historically performed, such as assisting walk-ins and answering the phone. There is nothing into record that contradicts or suggests that need wasn't genuine. It's also notable, as was mentioned earlier, that once she did return to the office, that there was a return of at least a portion of her compensation. As the complainant necessarily concedes, the board had the authority to modify her salary and benefits at any time. And at the fact-finding conference, the information was clear that this was in response to whatever the budgetary limitations were in a given year. So in years where there was ample funds, I guess there wasn't really a question as far as her receiving the benefits. In this case, it's clear that once they shone a light on the fact that she was receiving this type of benefits, that there were certain board members that were adamant at the public meetings that the $10,000 needed here should not come from raising taxes, especially when it was caused at least in part by complainant's reduction in duties. In some, at least for me in this case, there was no evidence that the complainant's compensation change was retaliation for instituting the COVID precautions in the treasurer's office, which was her sole alleged act of whistleblowing. I think, as I say, if nothing else, that once the board did take a look at her benefits, that there was some pushback as far as whether or not that was appropriate. So while it did come in or around the same time as the COVID concerns, for me, it was more just a situation where board members learned something that not everyone was aware of and used that as an opportunity to remove the benefits when they had a chance.
Thank you, Bob. Any commissioner questions for the investigator? Seeing none. Thanks, Bob. So commissioners, you've heard from the parties and the investigator. There's one proposed finding. Thank you very much. Happening.
Oh,
There we go.
I would move that there are no regional grounds. You want is that enough for me?
If I could supplement that, I believe what you are saying is no reasonable grounds to believe there is a lawful whistleblower protection act retaliation. The complaint should be dismissed.
Thank you.
Is there a second?
I'll second.
So it's been moved and seconded to find no reasonable grounds. Is there any discussion among commissioners?
I would just say that I was troubled by the timeline in this case regarding the benefits being not reinstated. I think I've been swayed by two factors. One, the fact that they did reinstate her salary when she came back to the office. And number two, respondents counsel's representation that these were different people sort of than the folks that had sort of approved the benefits in the first place. There's sort of a reevaluation of the investigators' comments regarding same.
Any other discussion among commissioners? Seeing none. The motion is to find no reasonable grounds to believe that unlawful whistleblower activity occurred. If you vote yes, you are in agreement with that. Commissioner Ashby.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
So it's 4 votes in favor of a no reasonable grounds finding and 1 recused. So the finding is no reasonable grounds, and we appreciate everyone's participation in the case. And at this time, I'm going to bring up a case that commissioners already decided this morning. As we may have mentioned, we've been having lots of participants having difficulty getting on the line. And it turns out that the complainant in the Stubenrod case was among them. So I recommend that the commissioners vote to reconsider their prior decision in that case.
So moved.
Okay.
Second.
Wait, hold on. Let me write it down. Hold on. Reconsider and seconded. All those in favor? Oh, nope, I can't do that.
We thought
The motion is to reconsider.
we
Thank you.
snuck it by you.
Thank you. The motion is to reconsider. If you're in agreement, you'll vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Okay, so we are going to return to the hearing. Return to hearing. Let me just check all of the messages, all of the emails that are everywhere. All right. So if we could bring up, we have Ms. Stubenrad, we have Mr. Libby. And I have a message from Ms. Stubenrad saying that she's trying to enable captions and not having any luck. Ms. Stubenrad, have you, the message across the top of my, as a host here, it says that you have enabled closed captioning. Are you able to see that transcript?
Yes, I was able to finally get them started.
Okay, great. So, we have Mr. Libby here on behalf of several of the respondents. I have messaged 2 of the respondents who I believe are not represented by Mr. Libby. And we have Kit just, nope, that's Colin. Colin is doing this case, and Colin, thank you, Colin. Let's try this again. So, Commissioner
No
Ashby,
reason-
yes.
No reasonable grounds case, and as a result, we need to hear from Ms. Stubenrod, or I guess she's not represented, so Ms. Stubenrod.
Ms. Stubenrad, you have 10 minutes. I would just remind you not to use the names of anyone who is not a respondent here, and also that any information that was redacted from your submission may not be mentioned. So with that, go ahead. You have 10 minutes.
Okay, thank you. I first want to thank the commission for hearing this case. And this is a case that involves 2 dynamics, in my opinion. It involves a landlord that was less than willing to maintain the condition of this property. And it also was later fueled by the revelation of my being transgender and the fact that both the landlord and the respondent, his employee, basically they engaged in an all-out campaign of withholding the necessary repairs. And also on one occasion, when I was on duty at my place of employment, I was subject to a very public berating by the respondent's employee as he walked by me, referring to me as a piece of shit. And I just told him to keep walking. I wasn't going to deal with that issue right there in the store. And I mean, he thankfully did just that. He just kept walking. But to back up, when I first revealed the fact that I was transgender to the landlord's employee, was because he brought a piece of mail that was addressed to me in my female name of Danielle. And he said to me, I thought you only had one lady living in your residence. And I explained to him that Danielle was me. I'm transgender. I'm still pretty early in the transition process. And he looked at me and he's like, oh, you're one of those. And he just looked like he had this total expression of disgust on his face. And he just walked right away from me. I mean, this has been just one incident after another. And this is what led to me filing a grievance with the Human Rights Commission, because this was just unacceptable conduct, a failure to maintain the condition of his property. And then when I actually did manage to get him to call somebody to actually do some work, that was done so haphazardly and so egregiously wrong that, the repairs just were not finished. And it's just like one argument after another. And it's just, if you pardon my use of the expression, it's kind of like a bad 80s song that you can't turn off, and it's just on a loop, on an instant replay. Well, that's where I petitioned the Human Rights Commission. And when back in February, when we held the first meeting, the meeting was not done according to standard, in my opinion. The first roughly 5 to 8 minutes of it wasn't even recorded. When the respondent's attorney came on, the investigator stated that, he had worked with her before, that there was an appearance of chumminess between him and the respondent's attorney. And this is a huge problem for me, because in my opinion, the whole purpose of the Human Rights Commission is to maintain, a position of neutrality. And it even says that on the Human Rights Commission website. Well, I have a problem with the chumminess of it. And even when we went into the evidentiary phase of submitting things for the investigator to consider, the respondent's attorney at the time waited until the very last day that evidence could be submitted. And then at 20 minutes before, because if the time frame was that we had until 5 p.m. on that day, and at approximately 20 minutes to 5, the respondent attorney submitted a letter claiming to have had a discussion with a manager over at VIP about the fact that the trash that I was being accused of dumping was in fact being dumped by the respondent's attorney, or not by, sorry, by the respondent's employee. My apologies. It's the first time I've testified for a committee like this, so I will beg your forgiveness for a tiny bit of nervousness, but and this is just when she made the allegation of, a discussion that I wasn't even able to have any time to try and validate. I took serious issue with that. I also took serious issue with the fact that a photograph supposedly presenting a large assemblage of trash, taken by the respondent's employee, even in looking at that photo, you can see that the supposed pile of trash in the foreground doesn't have any shadows behind it. So, I mean, I have nothing more than my own opinion to back up what the fact that this was a doctored photo, and I wasn't even given the electronic file to try and challenge it with. But I took a picture of the actual amount of trash and submitted that to show that the amount of trash, and, the claim that the respondent made that, if I was having trash being dumped into my garage, why didn't I open it up and take a look at it? Well, during a pandemic, the last thing I'm going to do is open up bags of trash, or even post-pandemic, I'm not going to open up bags of trash. I don't know what's in it. I don't want to know what's in it. So yes, I get rid of my trash. I go through Gregory's disposal. I've been taking my trash out religiously every week. It goes right in the toter. And I showed him the amount of trash that actually was there. I've even taken pictures of the respondent's employee purposely positioning his truck to block access to the driveway, purposely driving his car around his personal vehicle. It's the red sedan vehicle that's in the one picture I sent, and positioning it around the opposite side of 18 Bow Turf, which is, there's no reason for his personal vehicle to be around that side of the garage, except for he was taking trash into a house that since day one, I've never been able to lock this house. Okay. Since day one, there's been dry rot through many parts of the house that I've tried to get addressed. The front porch sags so badly that it's dangerous for people to even walk on it. And I've raised these issues as well. And it's just like these issues fall repeatedly on deaf ears, you know, and I have to admit, you know, this is, you know, with the political vitriol that surrounds the whole issue of being transgender, I don't know where the bias is coming from. You know, as I like to kiddingly tell people, but seriously, it's way above my pay grade. But I will tell you this, that on May 6th, the respondent's employee, his wife, apologized for the animosity between the two households. So, I mean, you know, I don't know if that was her way of trying to somehow smooth things over or what it was she was trying to do. I mean, she even brought over some birthday cake from her son's birthday party. You know, she later gave my wife one of the bagels she had been making. You know, I don't know if it was just her way of trying to smooth things over or trying to apologize. And even reflecting back on what happened on January 3rd, when her husband, you know, referred to me as a piece of shit, I even remember seeing her roll her eyes the minute he said that. So, I mean, that's another point, a point that supports this behavior. I mean, I'm not trying to justify his behavior or even the landlord's behavior, but, you know, at some point, you know, since day one, it has just been my opinion that the landlord just has never dealt in good faith. I mean, there are still 2 garage doors that I have to open them manually. He promised that they would be fixed, you know, when I rented the house. It's never happened. The furnace room, the light in it still doesn't work. You know, the front door can't be locked. The sliding glass door, that thing slides open. You know, I'm constantly having to shove that thing closed. I mean, it's just problem after problem after problem. And then, you know, the problems that I had with the respondent counsel, you know, asserting that a conversation occurred 20 minutes before the whole evidentiary timeline closes. Even though the evidence timeline had closed, I still went back to BIP and tried to, you know, verify that conversation. Wasn't able to verify it. To their knowledge, that conversation didn't occur.
Mr. Monroe, can I ask you
I mean,
please not mention the names of any third parties, like the place where you were
okay,
gone?
I wasn't aware I'd mentioned anybody's name. My apologies.
Thanks.
That's why I'm using general titles, and, you know, so that way it establishes a point of reference as to who I'm talking about. I want to make sure that the information I'm giving you is clear, concise, you know,
Okay, you
that
have
it
30 seconds
establishes
left.
that.
You have 30 seconds left.
Okay, then, and 30-second wind down, I guess, would be to say that this is a case of a landlord not wanting to take care of his property, and then later in finding out that his tenant was transgender. And I do use feminine pronouns, but it just fueled the fire. And because of that, here we are.
Thank you. Commissioner questions, Commissioner O'Brien?
Thank you. There were some dates in here that kind of confused me, but am I correct that you moved in February of 2020? And you're saying from day one, it was a bad situation, maintenance wise and other. But again, correct me if I'm wrong, but that it was in July of 2022 that you were certain that because of male, they knew you were transgender, and the discrimination, this is a discrimination case based on gender identity. So can you speak to that timeline?
Well, initially, our move-in was in 2019, actually, because we moved in before the pandemic started. And to the best of my knowledge, I don't know exactly when he found out about my being transgender, Okay, the earliest thing that I can point to would be last year, because I had exchanged emails with him. I had identified myself as transgender. So the first time that the respondent found out about it was last summer. The first time his employee found out about it was when the mail that was addressed to me in my feminine name of Danielle was placed in his mailbox instead of mine. Okay, so I'm not sure exactly when the conversation occurred between the respondent and his employee. So I can't speak to when the two of them spoke to it about it, but I can just say that that was when I found out that, his employee knew about it and that he knew about it in those two timeframes, and that there had been a pretty significant back and forth about the maintenance of the property and the fact that this was a situation that was just getting worse exponentially, and with him being down in Florida, that made it pretty difficult to have a direct conversation with him face to face about all this stuff. I mean, I sent down as many photos as I could via email. I tried to make sure that, like in my dealings with you, trying to make sure that I'm presenting clear, concise information, that you're able to connect the dots from A to B to C to D and so on. But
Thank you.
there's only so much I can do.
Are you still living there?
I am.
Okay, thank you. Thank you.
Any other commissioner questions for complainant? Seeing none, thank you. And I believe we have counsel for at least two of the respondents is back. Mr. Libby?
Yes, that's correct. Good morning, commissioners. Thank you for hearing this case. I am the attorney for George McDonald and Tanya Botter. The other two respondents, Jeff Baldwin and Victoria Pease, I believe are unrepresented. And I'm actually filling in today for Allison Knowles, who's on maternity leave. I don't have much to say. I will say that we agree with the investigator's report. We thought it was thorough, thoughtful, and correct. We asked that the commission confirm the ultimate outcome in that report, which is no reasonable grounds of discrimination. And I'm happy to answer any questions if anyone has them.
Admirably brief. Commissioner questions for Mr. Libby? Not seeing any. Thank you, Mr. Libby.
Thank you.
I don't know if I did contact Mr. Baldwin and Ms. Pease by email to let them know that we would be rehearing this. I don't know if either of them is present. If Mr. Baldwin or Ms. Pease is present, please unmute yourself. Don't know that they are here. I will say that Ms. Steubenrod had about 5 seconds left. Ms. Steubenrod, I'm not sure how much you can, if you want to, or how much you can add in 5 seconds, but you can if you want.
Other than to thank the commission for its time and to state that because the two employees, the respondent's employee and his wife are not present, that there's no way to verify the apology, but other than the fact that it did occur.
Ms. Steubenrod, I was going to not mention that, but that actually allegedly occurred. If that did occur, happened after the case, the record was closed, so the commissioners should not consider that anyway. They are limited to considering things that happened within the evidentiary period, and that happened after the report was issued. So
Understandable.
that was your remaining time. So commissioners, Colin Hurd was the investigator. Hello again, Colin.
Good morning, Commissioners. I'm Colin, and I was the investigator for this case. I don't have too much to say about it, except that the complainant is right that the first 5 minutes or so of the conference that we had was not recorded, but I also wanted to point out that that's not a procedural requirement. It's something that we as investigators have the option to do. It just helps us with being able to go back and look at the investigation. So it's mostly for our own personal convenience. And then I also wanted to state that, I did receive all the photographs and that both parties sent to me and reviewed them very carefully. And I'm 99% certain that the photographs were not photoshopped. And that's all I have to say. I'm open to any questions you may have.
Any commissioner questions for the investigator? Seeing none. Thank you, Colin. So commissioners,
Thank you.
we are back to where we were, which is that there is one proposed finding. The proposed finding related to claim of discrimination based on sexual orientation or gender identity. So we would be looking for a motion from the law.
I'll move that we find there's no reasonable grounds to believe that those respondents engaged in unlawful discrimination and the complaint should be dismissed.
Second.
So it's been moved and seconded to find that there are no reasonable grounds to believe unlawful discrimination occurred. Is there any discussion among commissioners?
Complainant in his own testimony here.
Her.
Yeah, I'm sorry. In her own testimony here today said that this was a case of a landlord that wasn't interested in maintaining the property from the beginning. And that's one of the investigators' findings, that the timeline of finding out about his gender status, her gender status is not until later on, after a lot of those complaints. So it doesn't add up that there's a tie to unlawful gender discrimination.
Any other discussion among commissioners? Seeing none, the motion is to find that there are no reasonable grounds to believe respondent discriminated on the basis of sexual orientation or gender identity. If you're in agreement, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
The findings are no reasonable grounds to believe unlawful discrimination occurred, and the commission will send parties and counsel a letter confirming that. We thank you all for participating, and I do apologize again about the difficulties with folks getting online.
I'd like 5 minutes, please.
We will take a 5-minute break.
Thank you. All right, you ready?
Yep.
Our next case, PA 210219, Jeffrey Dana Berkowitz on behalf of the minor child versus Nonitum Resorts, Jin Marlin and Tia Hewitt Gordon. This is a reasonable ground, Katie. As a result, we should hear from respondents, actually respondents counsel, I believe.
Yes.
Good morning, Commissioners. Tani Alvarez on behalf of respondents, Nonantum Resort, Jean Ginn, Marvin, and Tina Hewitt Gordon. I would request 2 minutes to be reserved. Respectfully, Nonantum finds and believes that there are 2 errors or omissions in the investigator's finding and would draw the Commissioner's attention to those to begin with. And the first is lacking information in the investigatory findings itself concerning Exhibit 3 to respondents' response to the charge of discrimination, which was in full the language that was included in complainant's March 31st, 2021 email, which serves as a basis for much of the reason why we're here today. Within that email, there was a request that provided part of the luxury of vacation is having a clean room every day and not having to do it. I can't spend 2 hours a day cleaning our room, parentheses, hotel housekeeper, name used but not used for this purpose, took 45 minutes to an hour when it was just her, and she is in much better physical shape than me. We are always generous with housekeeping every day, but it is something, please, we really need to have daily. One of the reasons we stopped staying at third parties' home is because cleaning bathrooms, cooking, changing sheets, vacuuming carpets, all was not a vacation for me. Once a year, I need a break. Please let me know if housekeeping can come in daily. This was in regards to a request to have housekeeping coming in daily, which during the course of the summer of 2021, based off of COVID protocols, as well as decrease in staff, was simply not something that Nonantum could do. As set forth in the investigator's report in 2021, during this period of time, the resort had 149 staff members. This was almost 50 staff members less than it normally had during this period of time, and 91 of them were guest facing. In 2019, pre-COVID, they had 28 housekeepers, but in 2021, during that summer, there were only 18 housekeepers, so 10 less than what usually the organization had, or a third. As a result of that, daily housekeeping wasn't something that was offered to any guests. So the first area of concern as to the investigator's report is regarding the whole statement within the complainant's request for additional services from Nonantum. Additionally, the second area of concern that Nonantum has as to the report itself goes to the finding that is set forth on page, 3 of the investigator's report, in which there is a finding that there's no indication that respondents canceled the reservations of non-disabled guests. While during the course of the conference, respondents did provide testimony that we lost guests due to restricted COVID protocols and individuals being upset that Nonantum was not offering a buffet breakfast and that individuals wanted daily housekeeping. Of significant importance here is the fact that there is no comparator data. We do not have another family that had stayed with the Nonantum for 40 days in the past, who the Nonantum had already seen how they act as guests, the care that is needed for them. And when I say the care that is needed, I'm not talking based off of any disability status, just the general high maintenance needs of this family itself, whether it's based off of shuttle arrangements, whether or not it's based off of food needs or other activities that were necessitated. This is extremely important, specifically this fact that there is no comparator family as it relates to the findings concerning retaliation. I'd now like to turn to some concerns as to findings within the investigatory report based off of what I believe to be errors in the law. Specifically, the investigator found that there was an undue burden here, that in order to accommodate what was being requested by complainants, specifically daily housekeeping, that this would have served as an undue burden to Nonantum. However, there is then a finding that this is pretextual in some way because there is not another family in which the Nonantum canceled the reservations for in 2021. The problem with this analysis is that there is no comparator data to show this. There were multiple individuals who had disabilities who stayed at the Nonantum, and that's, you know, apparent based off of laws which require it to have handicap accessible bedrooms, handicap accessible suites that were occupied during the course of 2021. So from a retaliation standpoint, because there is no comparator data, to then show that it was pretextual and that the undue burden that would have been caused by providing the accommodation of daily linen changing was pretextual is just not supported by the record. There's no pretext that has been shown in this matter. Additionally, from a failure to accommodate or failure to grant a reasonable modification, in this situation, there's a finding by the investigator that the March 31st, 2021 email that makes multiple different requests includes multiple non-disability related requests, but then also includes this language concerning housekeeping. And I've referred you back to the email itself, which talks about housekeeping much more from the luxury standpoint about the need. There is data in there concerning the individual's disability and how this ties in. However, there's only one element of housekeeping that is related to the disability. That would be the changing of linens. However, there is a request for the room to be vacuumed daily, for the bathroom to be cleaned, all of these additional things. The investigators' findings find that it would have been appropriate for Nonantum to engage in reasonable accommodation dialogue to determine whether or not it could further accommodate complainants. There's no basis within the statute under federal law or state law that a public accommodation has an obligation or a duty to participate in an interactive exchange or dialogue with somebody who is requesting an accommodation. Instead, the standard specifically provides that a failure to make a reasonable accommodation in policies, practices, or procedures, if those modifications are necessary to afford services or privileges to accommodate or accommodations to individuals with disabilities, unless in the case of a private entity, the private entity can demonstrate that making the modification would fundamentally alter the nature of goods, services, facilities, privileges, advantages, or accommodations. Here, there would be a fundamental change in the accommodation itself that was being provided. No individual during the summer of 2021 was being provided with daily housekeeping.
So that's 2 minutes left.
I'll reserve the remaining 2 minutes and happy to answer any questions that the commission may have.
Any commissioner questions for respondents council? Yes.
So I understand your point about what you believe the requirement of interactive dialogue is regarding a requested accommodation. And perhaps it's not required by rule or statute, but in an effort to determine the reasonableness of the request, which is in fact the defense you're raising, how else would your client be able to determine what exactly was being requested and whether it was reasonable? I mean, I see that email as well, and I'm thank you for providing the entire thing. And I agree that only a small part of it is a specific request related to a disability. But doesn't that cut against your argument that if instead of saying, well, I guess we're just not going to see you, good luck in your future endeavors, but instead your client said, yeah, I see that you're asking for a lot here. Well, what do you really need to accommodate your disability? Maybe changing sheets is quite a bit different than providing full housekeeping services, for example. Wouldn't you be in a better position if your client had done that?
Respectfully, Commissioner, Nonandam had 40 stays with this family. So in this situation, I don't believe that it would have been in a better position. The email was clear, and we have multiple past years of requests. Knowing what its staffing levels were for that summer, the difference in time between any aspect of coming in daily into a room and turning it over, in complainant's email itself, it notes that it would take a housekeeper over 45 minutes in order to perform these tasks, right? If we then do that based off of every day and we provide that service when it's not directly related to the disability, it's an undue burden, and it's not something that could be accomplished. Similarly, had they attempted to have further conversations, their past experiences with this family, and this is part of the record during the course of the investigatory hearing, was that they felt as though if they did one thing and said, yes, we can accommodate just bed linen changing, that there were going to be multiple requests throughout the visit for all these other accommodations to be provided. And when I say accommodations, I don't mean accommodations based off of disabilities, but accommodation from a hospitality, the luxury, that was expected by these guests.
Well, I don't want to get in an argument with you, but there's quite a difference, right? Yes, they could have in fact followed, if we adopt the investigator's report, they could have followed the law in accommodating the request regarding the disability, and then they could have quite cheerfully said no to all of the other requests, and they wouldn't be before us, or if they were before us, perhaps our investigator wouldn't have made the same kind of finding, right? I mean, again, I can understand the idea that, oh, these folks are kind of a bother, and it's really a strange time in history, and we're short-staffed, and I just can't deal with these people this year. I'm reading between the lines, it seems to me that's what was happening, but it was happening because one of the requests that was made was a request for an accommodation for a disability.
Commissioner, what hypothetically could have happened if things had been handled differently, I can't speak to. I can speak to the fact that the Nonandam did what they were required to do under the law. And if we were to create a system in which an interactive dialogue was necessary for every time in which a public accommodation, an accommodation or modification of policies is requested, I think it would become untenable for many retail locations and for other venues in order to have an extensive dialogue. In the employment context, that's appropriate and available because you have an employer and an employee who have this ongoing relationship, as opposed to in a public accommodation context where that in most situations is not the case.
Okay, thank you.
Commissioner Douglas and Commissioner David.
Yeah, just a brief question. The investigator's report suggests that the complainants were permanently banned from the resort, which then undermines your position that this was related to COVID, created staffing shortages and things. What's your response to that?
The language that was set forth within the responsive email to this request was that things have changed so dramatically as a result of COVID-19 that we simply cannot meet your request. We thank you for your past patronage, and we wish you all the best. At that time, there was not a permanent ban. It is the Nonandam's policy, kind of more generally, that once somebody sues us, that we're not inclined to invite them back to the entity.
Thank you.
That's kind of a startling revelation, though, isn't it? Isn't that a retaliatory position?
For any lawsuit itself. So if somebody tripped and fell at the location, all of those different behaviors would not invite us back. On the record itself, kind of what they said to complainants was, we thank you for your past patronages and we wish you all the best. There was nothing in there limiting their ability to be guests again in the future.
Forgive me for interrupting you.
All set.
You all set?
Yep.
Commissioner Davis?
What was the history with these guests? Was it 5 years of staying?
It was 40 specific visits over the course. I believe it was approximately 2016 to 2019, and I apologize as to the beginning year, but it was approximately 10 nights, give or take a year. Sometimes there were one year there was 2 chunks of visits, but there had been an ongoing multi-year relationship with these guests.
And respondent writes to them about the reservation that they made pre-pandemic in March of 2020, saying, we have these problems, we're not sure we can accommodate you. Is that fair?
In 2020, there was, the complainants had canceled their reservation because of COVID. In 2021, they reach out saying, hey, you took your 2020 reservation, we pushed it to 2021. We're calling, checking in because we don't have your deposit. And then we also don't have, and we want to make sure that you're prepared to proceed. It's primarily a deposit. And then here's an outline of what our practices are going to be this summer so that people are aware, because everything was so different as a result of COVID.
Isn't your best argument that saying we're writing you to see if you want to proceed, isn't that an interactive process about their ability to stay there?
It was provided to every single person who had reservations who hadn't provided a deposit. So this wasn't specific to complainants. It was something that was performed to update everyone on, hey, this is what you can expect from your stay.
And they had not provided a deposit for the new reservation a year later, for pushing after the reservation is pushed from 20 to 21, right?
That's correct.
Thank you.
Any other commissioner questions for respondent at this time? Okay, seeing that, you'll have 2 minutes when we come back to you. Now we'll turn to Mr. Berkowitz.
Good morning, commissioners. Thank you for your time and willingness to hear this case. Fundamentally, the non-ante misses the point. First of all, I do believe that the statute contemplates an interactive dialogue, but even if it does not, if you look at section 4592's first paragraph, it makes it very clear in its language that the non-ante had no right to substitute its judgment as to whether we would be comfortable after they answered the questions my wife was asking with respect to accommodations related to food, with respect to housekeeping, and ignores the fact that I physically, if I have to clean a room, change bed linens, will do so. You also have to put yourselves in the shoes of my wife, a 52-year-old woman who frankly wets the bed more often than we like to admit. She's not going to sit there and write, because it's embarrassing, and it's come out in the record that the non-ante shares things well beyond the front desk in terms of interactions, that she wets the bed. So she couched it. If I was in a similar situation, talking with people that I know, but I'm not, on close, intimate terms, I probably would have couched it too. And instead of responding to the questions, and there is in the record a draft email responding to the questions, it's a terse email that says, thank you very much, we can't accommodate you, go find someplace else to stay. And what it doesn't say is, and when the COVID restrictions end, please come back. It essentially says, go away, never come back. And these intimations that we were difficult guests are undercut by the fact that when the August 2020 reservation was canceled, I had already made a reservation for in May of 2020 for August of 2021. If we were that difficult of guests, it would have been a situation in which no reservation was made. It comes down to the fact that my wife emailed, perhaps she should have picked up the phone, but then we wouldn't have the paper trail. My wife emailed asking questions about what the stay would look like in terms of essentially, can we get the roommate up? I can't physically do it. I've done work for hotels as a lawyer. I've stayed in hotels. My kid, because of his autism, loves to walk the floors of hotels and explore. I've seen what hotel rooms look like pre-COVID on checkout. I've seen the piles of linens in the hallway. It's unrealistic to expect on a 13-day stay to come in every 3 or 4 days. But setting all that aside, the big overlay is the inability to even get confirmation of fresh bed linens. And the non-anthem has never, in this case, said anything about providing fresh bed linens. We've talked about towels. We talk about a bunch of other things, but we don't talk about fresh bed linens. We have an argument about peanut butter and jelly sandwiches, if requesting it to take it off, something off the menu would be that difficult. My son, and until you live autism, you don't even begin to understand it. I actually read an article in my local paper yesterday making that exact statement. We're not talking about asking something to be taken off the menu. We were simply asking to understand what the food contours would be like. His food choices are so limited because of his autism, it will drive you nuts. But we were simply asking, if you have pancakes on the menu at breakfast, can we have them for dinner? We would have settled for something being reheated. Waffles is another example. We weren't trying to be difficult. We were trying to understand what was going on, and the non-anthem substituted its judgment. We'll never know what would have happened if they had come back and said, we can't do X, Y, or Z. But it was our decision, ultimately, not the non-anthems. The statute clearly outlines that fact in the I'll call it the preamble. It's really an operative set of language, but it clearly contemplates that there should be an interactive dialogue. With respect to the comparable data, I simply note, if you're going to micro define it away, of course you're not going to be able to find find a comparable guest. The respondents were asked at the hearing whether they had canceled anybody else's reservations. They point blank said no. They were asked in the investigators' initial contact with them for documents and requests 8, 9, and 10 for information that would have allowed somebody to develop the comparable data. They interposed the typical litigation objections to avoid having to respond. Request 10 in particular specifically asked for that information, and they were told that they had an objection and it wasn't relevant. It was clearly relevant. And it goes to the issue of whether the disabilities were the cause of the reservation being canceled. And I wholeheartedly agree with the investigators' findings. And I'm not going to belabor the point. I'd like to use the rest of my time to answer any questions that the commissioners may have. It's not that complicated a case. They substituted their judgment and they banned us permanently.
Thank you. Any commissioner questions for Mr. Berkowitz? Commissioner O'Brien and Commissioner Douglas? I'm sorry, Commissioner David, sorry.
All the conditions that need to be accommodated are present pre-pandemic and present during all of your stays in the 3 years or 5 years. I saw a reference to 5 years, I thought.
I believe it was 5, yes.
I believe it was 5. So they're thoroughly acquainted with your requirements, correct?
Yes.
And so what is your theory as to why, after that history, they say they can't accommodate you?
They were using it as an excuse to
accommodate you, but you know, anyway, go ahead.
I believe they were using it as an excuse to get rid of a disabled woman that frankly was leading to bed linens having to be changed more often than they normally would have liked, an autistic son who can be difficult, And yes, circumstances may have changed,
So
but
they put up with it for 5 years and now are saying, well, that's enough, we're sick of it?
I think it was more the related questions, and the bottom line is there are other hotels in the area that had similar conditions. And it was our decision whether to stay or not. And frankly, the reason we didn't come in 2020, I have elderly parents who live in Kennebunk, and we go to stay with them. But at the end of the day, all the hotels had similar restrictions. My wife was asking whether an accommodation could be made with respect to bed linens, rather than coming back to us and saying, no, we can't do that. It's, we'll take it for purposes of this question, and I'm not conceding the point that we'll take it that it was an undue burden. I don't think there's sufficient proof in the record of that.
Well,
but assume there was an undue burden. I having, after the reservation was canceled, calling around and trying to find a reservation for August, which was extremely difficult at that late point in the season, because reservations are usually made the previous summer. Been coming up to Maine for close to 50 years. But from a practical standpoint, a lot of the hotels had similar restrictions. I changed the beds. I didn't even have that option because my wife asked questions. Right there was the discrimination. I agree with Ms. Morse that it was far beyond that. And I did not mean to talk over you, Commissioner. Go ahead.
Yeah, both of you are talking over each other. If we could ask Mr. Berkowitz to only answer the questions that are asked, that would be super.
And I was trying to, and I apologize if it became longer than that.
You're saying that their response to the request for accommodation was no, and that was pretextual and not based on the staffing and the pandemic conditions, correct? Is that the theory?
My theory is, yes, that's it. And look, but let's be clear. The answer could have been no, but we can give you fresh bed linens. There's no evidence in the record that was even an option.
Thank you, Mr. Berkowitz. Commissioner Taylor, you all right?
Yes.
Were there other commissioner questions? Commissioner Douglas?
Yeah, just to follow up on Commissioner Davis' questions, and it wasn't clear to me from the commentary so far, the requests that were submitted this particular year, were they substantially different from the requests that were submitted before?
Yes, and they were driven in response to the COVID-related questions or COVID-related procedures that were outlined. And there is one thing I should note, that the request for the deposit, I wrote back to the front desk manager to not use her name, and it said, can I send this to you by the end of April? And they agreed to that. So this isn't about the deposit. This is about the questions. And there was a reasonable middle ground, and there was no iterative discussion.
Mr. Berkowitz, if you could just answer the question that's asked, we could probably move this along, because I think Commissioner Douglas is waiting to ask you a follow-up.
Okay.
I was, thank you. And so to ask my follow-up, you agree, right, that in prior years, there was no dispute that the hotel, the resort accommodated your requests, right? They accommodated all your requests of previous years, true?
As far as I know, yes.
Thank you.
Any other commissioner questions for Mr. Berkowitz? Seeing none, Mr. Berkowitz, you'll have 4 minutes left when we come back to you.
Okay, thank you.
We're back to Respondents Council. You have 2 minutes.
I would just bring the commission respectfully back to the standard that's set forth in the statute, which sets forth that public accommodation needs to determine whether or not the accommodation being offered would result in an undue burden, or if it would change alter the nature of the goods, services, or facilities or accommodation that's being offered. In this situation, provision of daily housekeeping would have altered the services itself, but more importantly, would have resulted in an undue burden to the Nonantum, both based off of COVID restrictions and general staffing. And it was COVID that led to this decision, specifically as it relates to over 40 stays in the past with this family. And I'm happy to answer any additional questions that the commission may have. And I thank the investigator very much for all the work that went into this report, despite my disagreeing with the findings themselves.
Any commissioner questions? Commissioner Douglas?
I realize this is somewhat subjective, but I'll ask you the same question I asked Mr. Berkowitz. Do you feel that the requests for this particular year were substantially different from the ones that the Nonantum fulfilled before?
No, I feel that there were some that went more specifically to different COVID restrictions, but much of the content of it was very similar to past communications about activity, shuttles, food, all of those type of services that the Nonantum as a resort provides. But in this year, more kind of based off of some of the COVID restrictions that the front desk had communicated in its initial email to the guests.
Just to drill down on that a little bit more, these requests that Mr. Berkowitz talks about in terms of clean linens and meals and things of this nature, the Nonantum had to accommodate those requests before. Is that right?
Yes. That is correct, with specific blankets, extra blankets, distilled water, changes to the room setup, locks being placed on the door at specific heights based off of the child's growth throughout the year, so that it was a safe facility, extra amenities, lotions, distilled water, the bed setup in a specific way based off of the room itself for safety concerns, all of those.
Thank you.
Just so we're comparing apples and apples, though, in the past, the complainant wasn't required to request daily linen as a special accommodation because it was provided, correct?
Prior to this, there would have been daily housekeeping, not daily linen changes specifically if necessary, but not, is my understanding that the record would show daily housekeeping, but I don't believe the record was clear as to daily linens. Definitely new towels and as needed, but housekeeping most definitely. I think linens if it was necessary, but that it's not the resort's policy to fully change sheets and linens for overnight guests every single night.
All right, well, let's not split hairs though, and I'm aware that in the past, other accommodations had been made at the request of the complainant, but with respect to housekeeping only, the only time a reasonable accommodation was made with respect to housekeeping was this year in question, correct?
As it, and I apologize, a reasonable accommodation related to the disability?
Yes.
In the past, there had been ones related to other aspects of the son's disability as to specific requests for specific items in the room, specific blankets and those type of.
I'm so sorry.
I apologize if I'm talking, sorry.
I interrupted you and I apologize because I didn't want to get off on the wrong tangent. I'm not saying it correctly. These people requested linen changes, which is part of daily housekeeping this year only, the year in question only. They had never made that special request with respect to their accommodation. They never made that request for an accommodation with respect to any disability prior to this year in question.
That, yes, there's not a written document that shows that, and there's no evidence in the record that it had been made orally to any individual.
So when my colleagues are asking you questions about, didn't they ask for these accommodations every year and you gave them to them every year, but COVID is the reason why this year they couldn't get these accommodations. They actually had never asked for that particular accommodation before because you provided daily housekeeping services.
Yes.
All right, I thank you so much.
Commissioner Douglas?
To get it back and forth with my esteemed colleague here. My understanding is that Mrs. Berkowitz and perhaps the son, they wet the bed, right? And so my question, I see Mr. Berkowitz nodding. And so my question is, you know, I believe you indicated to us that they don't change the linen every day, right? If you're staying for 13 days, they're not going to change the bed linens every day. Is that true?
That's correct.
Okay, but when the Berkowitz stayed at the Nonantum, if somebody went to bed, obviously there's a request to change linens. You're going to change those linens, right?
Absolutely.
Thank you.
Any other questions for Respondents' Council, Commissioner? Seeing none, thank you.
Thank you.
I'll turn back to Mr. Berkowitz. Mr. Berkowitz, you have 4 minutes.
Thank you again. And I keep coming back to it. Put yourselves in the shoes of my wife. We'll set aside my son, given at the time he's 9. And ask yourself, if you're not going to get your room changed every day and you have an accident, you want to know whether you're going to be able to get fresh bed linens. You also are probably going to ask the question in a way that is going to be perhaps obtuse, because you don't want to put it in writing and say, I wet my bed every night. Trust me, I get woken up every night when it happens. So you're going to bury the lead, to use a newspaper term. So she asked the question. The result was the reservation was canceled. It's a very simple case in terms of the, if you go through the record, and I can see that the commissioners have, you'll see that nowhere do they say bed linens. They say you can get additional towels and things like that at the front desk. And the bottom line, though, was if they weren't going to be able to accommodate, they should have simply come back and said, we can't accommodate it. Do you still want to stay? They substituted the judgment that belonged to my wife. And the statute clearly in the preamble makes it clear that you don't even get to the undue burden. And the statute also says when it gets to subsections A, B, and C, for purposes of this subsection, unlawful discrimination also includes, but most importantly, but is not limited to. And the unlawful discrimination occurred when they substituted their judgment at a minimum. And I think it ranges far beyond that. And I think that if the commission was to adopt the recommendations of the thorough and thoughtful report Ms. Morse generated and prepared, there is a very good likelihood of success in a court action. Thank you.
Commissioner questions, Commissioner David?
Did you just say that if instead of canceling the reservation, they had said, we can't accommodate you, do you still want to stay? That there would be no unlawful discrimination?
I think that was the proper response to it. Yes.
Yeah, you did.
It was ultimately, if it's truly an undue burden, and we'll never know the answer to it, it was our decision to make. I think the accommodation was appropriate, or some in between, such as providing bed linens, which is clear that they weren't willing to do.
You could just answer the question asked. I think that would be helpful.
I think you did.
I am trying to answer the question asked.
Are there any additional questions from commissioners? Seeing none, thank you. Now we'll turn to the investigator.
Hello, my name is Angela Morse. I was the investigator assigned to this case. To me, it pretty much boiled down to the fact that the respondent didn't engage in the interactive process. We don't know if there was an undue burden because we never got to that point, because the resort didn't exert any reasonable efforts to make a good faith determination to see if they could accommodate this family. And in banning a family that had such a long-standing relationship with the resort, I saw that as retaliatory. And I can answer any questions.
Commissioner questions for the investigator? Seeing none. Well said, Commissioner David.
Yes,
All right. Thank you, Angela.
Mhm.
So commissioners, you've heard from the parties and the investigator. There are two proposed findings. I don't know if you want to take them separately or together.
I suggest that we take them separately, and I'll move that there are reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability, denial of reasonable accommodation. And that conciliation should be attempted in accordance with the act.
Is there a second?
Second.
So it's been moved and seconded, the first proposed finding, to find reasonable grounds related to denial of modifications or services. Is there discussion on commissioners?
Our investigator just said that the gravamen of the conclusion is the failure to engage in an interactive process. I think there is an interactive process. I think they did engage in it. It's based on 5 years of history and an anticipatory email to them saying, you know, we know who you are, and we can't do what we've been doing the last 5 years. And there's a response, and their response to that response is, we can't do it. We'll cancel the reservation. I am troubled by the fact, well, maybe it's, I don't know, I'll have to think about the second part, the retaliation. Respondents and counsel sort of snatches, you know, it bothers me that they say that they banned them in the future because they brought this case. But anyway, on this motion, I'll be voting against it.
Yeah, I'm gonna chime in with Commissioner David and agree with what he's just said. I think there was an interactive process. There was 40 prior visits in which the needs of these folks were well known and accommodated, as far as I could see. And in terms of an interactive process, I think the issue that we have here is that we have a resort at the beginning of a pandemic, and you know, or in the midst of a pandemic, and some of these things are not negotiable. Some of these things, like changing wet bed linen, for example, you can't, you know, either the Berkowitzes are going to do it, or the resort's going to do it, and the Berkowitzes made it very clear they're not going to do it. So once you have a situation, we have two bedwetters in a room, and you know, the resort cannot accommodate due to staffing shortages, which I think are undisputed. I think that these sorts of things are really undisputed, and you can't negotiate them away. You know, we can't accommodate that. If somebody calls in the middle of the night and says we have a wet bed, that needs to be changed. And so I think these two factors, the fact that they had accommodated these folks before for 40 visits, and the sort of nature of what's being requested here being sort of necessary. You know, they needed to deal with these things and they couldn't. And so I'm going to be voting against this motion as well.
So I see it a little differently, I guess, in that if the only real relevance to the previous 40 visits might go toward the reasonableness of accommodating the request, and it tips in favor of accommodating, not the alternative. These people are long-time guests, high-paying, long-time guests at this resort with a prospect of probably future visits. And as such, it's maybe more reasonable to accommodate them than it might be to accommodate anyone else. But that's sort of also beside the point. The record isn't really clear about what specific disability-related requests were in fact accommodated in the past in those 40 visits. What we have before us is the record of a request of a change of linen due to a disability-related incontinence problem. And refusal on the part of the respondent to engage in any discussion about what exactly was required. Rather, no was the answer. And it might be that simply coming to an understanding of maybe only making housekeeping services available when there has been an actual wetting of the bed would be a way to deal with it. There might not be as many visits as needed. It might be simply that that these complainants would have responded favorably to just an offer of daily clean linen, and that would have made their lives a little easier, but wouldn't have met maybe the 100% request. There was no discussion about that, and there should have been. And the response, we're going to get there in a minute. We're going to talk about the banning. The response of the respondent is pretty telling, and that is, we're washing our hands of you. And it may be the case that they also, that the respondent was tired of these people. It very well could be, but part of the reason why they were tired of these people this time around was because they requested something related to the disability that was an accommodation. Now, the other question is it reasonable? There was no real analysis of how reasonable that was. I'm not sure that it is a given, with all due respect, that they were so short-staffed they couldn't handle that. I saw the numbers in the investigators report. By the way, great investigators report. I saw the numbers to reflect there were still dozens of staff available. And we don't know whether there were dozens of staff available for the night shift or for the daily cleaning. I'm not sure we got into that kind of analysis. I saw a reduction by a percentage in the staff after COVID hit, but I didn't see it down to zero or even close. And I just think that a conversation about that, about how much staff was available, how reasonable it was, I think it is relevant that these were guests that spent a lot of time there and spent a lot of money there. I saw in the investigators report that if full-time housekeeping was required, it was 7 hours. Is it 7 hours more? And I don't know in the whole scheme of the cost of a stay there, whether 7 hours of pay for a housekeeper is an unreasonable accommodation or a reasonable one. But we certainly ask public accommodations and service providers to make accommodations that cost them money. And that might have been something that happened here, but we never even had that discussion. We got a no. That to me is an unreasonable response and a violation of the law.
Jeff, we do know that they accommodated them for 5 years. We know that those conditions that require the special accommodation existed during all of those 5 years. That's why I asked them that. That's not a new request. They know the family well. And they prophylactically went ahead and said, we can't do that this year in that email. That's what triggered this. And I don't see that that's based on discriminatory, illegal sport.
There wasn't an accommodation in the past with respect to the changing of the linen. They changed everybody's linen on a daily basis for everybody for the past 5, 15, 20, 50 years.
Not Bedwood.
They didn't do that. Well, it was unclear. The response is unclear. I clarified with the respondents' counsel that they provided daily housekeeping services, and if linens were required, they were provided. And so the only difference this time around is that the complainants are expected to go 3 days without any housekeeping services, which might include the providing of linen. That's the reasonable request, the reasonable accommodation request that was made here. And that's never been made in the past because it didn't have to be made in the past. That's the difference. That's the difference between this year and those years, that no one ever had to make a special request in the past. It wasn't any hardship in the past to provide services that they provided to every single guest. With respect to bed linen, they were asking for the same kind of services, even though they were warned that they would only get those services 1 day out of every 3.
That's right. We can't
That's the reasonable accommodation request. That
we can't do what we've done for 5 years,
right?
Because of the condition.
Because of COVID.
Right.
Well, that's the respondent's position. Sure. Yeah. Right. But then the question becomes, sure, COVID has affected the amount of housekeeping you have.
Is that pretextual?
No, actually, is it a reasonable accommodation? They can say that we're short-staffed and therefore we don't have these resources available, but they never dig into a discussion about what resources actually were available and whether it was reasonable to pull someone in to work extra, to spend a little bit extra money on hourly wages for an employee to come change linens. Or they never even offered to give linens. I've already made this argument, but they never had the conversation. We don't know how much of a pain it would have been for them during this terrible time of COVID, which I agree was an awful era. But we don't know how big a pain it was for them to provide these services. They never discussed that with the complainants.
I don't want to have this go on all day long.
Why not? None of us. I've got no place to be except for.
But I'm just looking at page 2 of this report and the first full paragraph, and there's a pretty I think there's a description of the needs of this family that is instructive here. You know, I mean, these folks, they needed a lot of things. You know, rearranging the guest room, installing a special door lock, providing distilled water, plastic cups or breathing machine for bathing, special food, not setting aside a copy of print publications, extra room cleanings, purple blanket, heating pad. I mean, they were short-staffed. It was the pandemic. They had accommodated these folks before. I don't think it's discrimination.
Any other discussion among commissioners of the pending motion? Seeing none, the pending motion is to find that there are reasonable grounds to believe that respondents discriminated against complainants and or minor child based on disability. If you agree, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
No.
Commissioner O'Brien? Commissioner Walker?
Yes.
Commissioner Douglas?
No.
So it's 2 in favor, 3 opposed. So the finding on the first proposed finding is no reasonable grounds. Actually, the default, I take that back. The motion for reasonable grounds did not pass. If a commissioner wants to make a motion to find no reasonable grounds, you can do that. I think the result will be the same of. Right?
I think we should vote.
Okay. Barbara disagrees. She thinks we should, one of the commissioners wants to make a motion to find no reasonable grounds related to disability discrimination, that would be preferable.
I'd make a motion that there are no reasonable grounds to believe that the Mansion Resort, Jean and Marvin, Tina Hewitt Gordon discriminated against Berkowitz and or minor child based on disability.
Second.
I'm just catching up here. I just want to make sure I reflect the first vote. It's Jeff and Mark voting in favor of these programs. Okay, so the pending motion now is no reasonable grounds to believe that respondents discriminated against complainants based on disability, reasonable modifications and denial of services. If you are in agreement, you will vote yes. Commissioner Ashby?
No.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
No.
Commissioner Douglas?
Yes.
Okay, so we have the inverse of the first one. Let me just make sure I write down. So. Okay, so the finding on the first, with relation to denial of reasonable modifications and services, that is a no reasonable grounds finding. So then we need to address the number 2 in our report.
And I'd make a motion that there are no reasonable grounds to believe that no Mansion, Jean Marvin and Tina Hewitt Gordon retaliated against the Berkowitz family for engaging in MHRA protected activity. And
The complaint would be dismissed.
Complaint would be dismissed. Thank you.
Is there a second?
Second.
So is there this is a motion to find no reasonable grounds for retaliation. Is there discussion among commissioners?
Well, the investigator says, had the reservation cancellation occurred due to COVID, which she concludes it did not, I conclude it did, that the resort would have offered them something else in the future. That seems to go beyond a legal conclusion. I think I have to be consistent that it was not unlawful discrimination and therefore it was not a retaliation. I don't see how it's a retaliation to, no. Right.
Well, I mean, it's not part of the record, and it's the respondent talking on behalf of her client, but I witnessed her say that these people aren't welcome to come back because they filed a complaint with the Human Rights Commission.
I agree. I think that's another case.
That's killing me, but and I'm gonna, but because I believe discrimination occurred the first time, I'm gonna vote no to this motion.
And I agree that she almost, snatches defeat from the jaws of victory, but it's a different case.
Well, to be clear, the finding here is retaliation for engaging in MHRA protected activity. And it's specifically based on the fact that respondents went further. I am reading from the only full paragraph in the analysis on page 7. Here, respondents went further by not only canceling this 2021 reservation, but also making clear that complainants were not welcome back in the future. So it is based on the perception, at least at that time, that the complainants were banned. And I can vote however you want, but I just wanted to make clear that that issue was what was being addressed there.
Yeah, it's an interesting one. I mean, the Resorts Council stated in response to a question that that was not their intent. That was not the import of that email. So we'll just have to interpret for ourselves.
There a discussion among commissioners? Seeing none. The motion is to find that there's no reasonable grounds to believe that unlawful retaliation occurred. If you are in agreement, you will vote yes. Commissioner Ashby?
No.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
No.
Well, we are consistent in our positions. No, wait a minute.
I'm gobbling.
So there were 3 yeses, people in favor of the no reasonable grounds. So, both findings are no reasonable grounds.
Right.
We appreciate the parties' participation. We will send parties and council a letter confirming both findings, and thank you for your participation today.
Thank you. Our next case is E 21-0243. That's Jocelyn Smith versus Falmouth by the Sea. This is a no reasonable grounds case, and we should hear from the complainant or her representative.
I believe that complainant is here by phone.
I am. I'm here by phone and by computer. So it said waiting for the host to let me in, but I can go by phone if that is easier for everyone.
Yeah, we've had tremendous problems with our Zoom, so we actually don't see the people who say that they are waiting. And I know it tells you that, but we actually don't see that. But if we have you by phone, then we would love for you to proceed that way.
All right. And do you need my camera on?
Nope.
Okay.
Well, we can't see it if she's not.
We can hear her.
Right, but if she's not in the meeting, we can see it.
She's there.
Do you want to, I can turn my camera on my settings. That's fine.
Sure, that's fine. That's up to you, really.
I'm easygoing. Let me find the settings here. I hope this is not impeding on my 10 minutes while I'm trying to find the settings.
And honestly, it's up to you whether you want to have your camera on or not.
Having the camera on is fine. Again, it wouldn't let me in on my laptop. So I have to find my settings from my cell phone to allow the camera on. So that's what I'm, trying to do. So pardon me.
I think if you called in on the phone, I actually don't think that you can enable your camera there.
That's what I was saying.
Yeah. So I think you probably need to go ahead without the camera on.
Oh, no, I didn't call in. I used the link and it says I can use my camera, but I have to change the privacy settings on this iPhone 14 or whatever number it is. I missed my iPhone 6, but it's not I'm trying to turn the camera on and it says I have to change my settings. And so, settings, privacy, camera. So that's what I was trying to do. Oh, I think I found it. Zoom.
Oh, yeah, I don't. Here, yeah.
So that it doesn't go off and happen.
When it goes, when it goes dark, but before it goes up, I try to touch it, but I don't.
Good. So that's like, well,
Ms. Smith, how about if we give it another second and then we go ahead with you participating just orally? What?
She's not allowed to go.
Oh, God.
No, you don't. And you can call me Barbara when you do when it's no edit, that's fine.
Thank you. We are glad to see you, Ms. Smith. Can you unmute your camera? There you go.
All right, can everybody see and hear me?
Yes, we
Yes.
can. You have 10 minutes.
All right, 10 minutes. Okay, well, I'm not an attorney, so excuse me if I come across, I don't want to come across insulting or silly or not serious. It's nerves, and when you're not used to doing these things, I have to apologize in advance. So I did review the investigator's report, and there was several things left out of the investigator's report. Not only that, there were incorrect dates that were in this report. So looking at the report, the factual background, as a nurse manager, responsibilities includes provision of leadership, clinical oversight, consultation, direction, monitoring, training for nursing and nurse-related operation on her unit, responsible for clinical management of the residents, regulatory compliance, quality improvement, and outcomes, policy and procedure implementation, and achieving operating goals. In that, it does not say that I would be working the floor as a bedside nurse. That's what I was not hired to do. I was hired as a nurse manager. The second one, shortly after the compliance hire expressed a concern she had not been offered the opportunity to attend the leadership training program that the white employees attended. Respondent's director of nursing apologized for the disappointment and explained that the training was a very basic program not suited for a nurse manager. Okay, the other nurse manager who is white attended that class. It was for people in leadership positions. So I was a nurse manager. The other, so I'm not trying not to say names, the other nurse manager who is white went to the class. A nursing supervisor went to that class, a part-time nursing supervisor. So that is not correct because, again, I'm a nurse manager. The other white nurse manager was signed up for the class. A white nursing supervisor who is not in management was signed up for the class, and I was not signed up for the class. I only found out after the nurse manager accidentally, was telling me about it and said, "Oh, it looks good on my resume." So that was the first. It's like, if I'm also a nurse, why am I not, signed up for this class? And yes, I do believe I should have been offered the opportunity to attend, because the training would have been beneficial due to, not having much management experience. Most of these leadership training courses are designed for the company. So to learn the core values, how you're going to do those core values, practice, implement those core values. So I should have been offered to go to that class. The director, different training that deemed more appropriate for her level of education and experience. Doesn't matter that I have a master's degree, working on a doctorate, that is irrelevant when this is a leadership training class. However, declined the opportunity because she was upset that she was offered alternative training only after she expressed her dissatisfaction. Yes, I never would have been offered training if I never would have brought this to their attention. At the time, I didn't even say it was because of race. I said I should have been offered that same opportunity as the other nurse manager and the nurse supervisor. So what they did while they were attending their classes, they made me cover the nurse supervisor's floor assignment while she was able to attend the class. So that was my first issue. So November 30th, 2020, LPN, nurse supervisor, researched me on the internet while at work and gossiping about what they found. Regardless, I never say the research because her race. The issue is they had broke the gossip policy that First Atlantic Salmon by the Sea has, and there was no discipline. The white LPN was never disciplined for one, being on the internet while working, and two, not following the gossip policy. That same LPN also did the same, did it again to another black nurse. Again, no disciplinary. So she had broke this gossip policy multiple times. She happens to be white, and there was no corrective action. Now where I have my issue was I was written up for expired medications in the cart. So does the commission have all of the paperwork in front of them? I'm sorry, I'm not familiar with the process. I don't know if you have all the information or anything, but I provided tons of information.
The commissioners have the investigators report and any submissions after that.
And what?
Any submissions after that.
Okay, so you don't have all the evidence prior to the investigators report?
But this is not really a discussion time for you and me. This is a time for you to present.
I am not trying to have a discussion. I'm just trying to present and follow. So I'm just asking a question because I've never done this before and I'm not an attorney.
I understand.
Thank you. So I was written up for expired medications. And this was after I had written an email to the director of nursing, the administrator, and the director of HR, January 15th, on my concerns. I was being treated differently because of my race. I pointed out how I felt like I was being treated differently and my concern of the multiple drug conversions. I've been a nurse for 20 years, and I've never been in a facility with 6 drug diversions within a 6-week span. I'm from Ohio, and you just don't have that many drug conversions in a facility. And that is my license, and that's other nurses' licenses. And they were all concerned of all those drug diversions. And so I did put that in that email that I am concerned about those drug diversions. And it was after that January 15th email that I was written up on February 10th for expired medications in the cart. However, I started there on October 2020, and they wrote me up for medications from August 2020, and I hadn't started there yet. And so it says there were expired medications dated as far back as August 2020. I didn't start there till October 2020. So I'm trying to go through this investigator's report here. Sorry, excuse me. Okay, and also an investigator's report. In 2020, state surveyors discovered expired medications in the facility's medicine carts and placed the facility on a performance improvement plan. Under the plan, regular audits would be performed on the 15th of the month, and soon to expire medications would be pulled. Compliant was responsible for auditing carts in her unit and documented she performed these required audits on November 15th, December 15th, and January 15th. The director audited the medication carts on February 8th and February 9th of 2021, and discovered medication treatments and supplies that expired as early as August 2020. Okay, here's the issue. In March of 2020, because I spoke to the woman at DHHS, in March of 2020 is when state surveyors went out and found expired medications way before I started. The facility did have a performance improvement plan in place. And when the state surveyors came back out in December of 2020 and did their investigation, there were no expired medications in the cart. I do have the woman from DHS name and contact information. I did supply that information to the investigator. The investigator would not accept that information because it was past the submission date. However, I have no control when DHHS contacted me. I was blowing them up to try to get this information. The lady did apologize. She gave me the information. We had a nice 10, 15-minute conversation. After conversation, she offered me a job to be a state surveyor. Anyways, so that is important information, because if the write-up is saying they found it.
If I could excuse me, you for just a minute, and I'm not counting this against your time, Ms. Smith. The information that you are speaking about and continuing to speak about, it was not allowed because it was submitted after the evidentiary record closed. I understand that you are arguing that you could not control that, but it still was not within the evidentiary record that the commission.
And that's fine.
Actually, if you could let me finish, I would appreciate it.
Oh, sorry.
So it can't be discussed with the commissioners. So I was going to let it go, but then you kept talking about it. So I'm going to ask you to not discuss it further.
Okay, I won't discuss it further, and that's fine, because at that point, that we talk about criminal if you're planning expired medications in someone's medication card. So, whether the commission sides with me or not, I'm already planning to contact the Attorney General's office to ask for a criminal investigation, and Falmouth by the Sea Police Department to do a criminal investigation as well. So again, I understand it was after, you could scratch it and not consider it, that is fine.
If I could, I'm sorry to interrupt you, but now that is your 10 minutes.
That was quick.
Yes, it goes quickly, doesn't it?
Hey, like I said, whether you side with me or not, I'm involved in other government agencies. So that's my 10 minutes. Thank you.
Okay, well, let's just see. Commissioners may have questions for you. Commissioners, any questions for Ms. Smith? Commissioner David?
Ms. Smith, was there an alternative seminar that they offered you after they didn't register you for the one that you think you should have gone to?
They did not offer me a particular seminar. So when the other white nurse manager and the white nurse supervisor were offered to a particular leadership seminar, I was not given an alternative. They did not say, oh, hey, we're going to put you in this seminar based on your education experience.
So
after the omission was discovered,
did they try to make it up with another leadership seminar?
No, they asked me if look through a list of classes, and if you want to take one, we'll sign you up.
Okay, thank you.
Any additional commissioner questions for Ms. Smith? Seeing none. Thank you, Ms. Smith.
Thank you.
So now we'll turn to Falmouth by the Sea. I believe Attorney Rand, you're here for them.
Yes, good almost afternoon, commissioners. So complainant alleges that she was subjected to a hostile work environment based on either race or alleged whistleblowing activities. She resigned her employment, so therefore she's also alleging she was constructively discharged. The investigator correctly assessed that the complainant does not have an even chance of establishing either race discrimination or retaliation. I'll be brief, but I would just like to remind the commission of a few facts that are not disputed. One is that management knew of the complainant's race when they hired her. They also knew of her race in December, months after they hired her, when they successfully convinced her to retract her resignation, asking her to please stay because she was valued. Someone other than complainant reported that potential drug diversion on December 12th, 2020. Complainant was not the individual who brought that to their attention. And the complainant reported the same concern 2 days later. Far from showing irritation or anger at either of the reporters, the facility voluntarily went to the police in the AG's office with information about those diversions. There is no evidence that complainant or the original reporter were punished for speaking up about that. Complainant's 90-day evaluation took place in January of 2021. That eval is in the record, and it has a lot of positive feedback. It's not consistent with complainant's narrative that management was looking to push her out. In February of 2021, complainant's manager performed an audit on the medication carts and found expired medications. Exhibit B to the respondent's initial submission includes a statement from the manager that responds to the complainant's argument that she reiterated here today, that she was not hired in August, and therefore how could she have been responsible for expired medications that expired in August? And what the manager said is that while the performance improvement plan was being developed when DHHS came in March, it was implemented in October of 2020, which is exactly when the complainant started her employment. So she was responsible for those audits. So that's not good that there was expired medication from August on the cart, but it should have been discovered in October, November, December, January. The complainant was given a written warning because of her failure to audit the cart and for falsely documenting that she had done so and that there were not expired meds on the cart. And importantly, after complainant's resignation, a white nurse who stepped into complainant's role also received disciplinary action for failing to audit the cart in a timely way. So while she contends that she was compelled to resign, complainant doesn't allege anything even approaching the hostile work environment threshold. And there is no evidence that the reason for that written warning was a pretext for discrimination or whistleblower retaliation. The investigator's report accurately summarizes and analyzes the evidence, and we urge you to adopt her recommendation. And I'm happy to answer any questions.
Thank you. Any questions from commissioners?
Would you review the time again, the time that elapses after the complaint of the serious drug diversion and before the audit of the cart?
Yes, so colleague reported drug diversion on December 12th. The complainant reported it on December 14th. And February of the following year is when the cart issue was discovered.
And you just said that another nurse supervisor was written up for expired medication. Sounds like it's a common problem. How often are the carts audited?
The carts are supposed to be, sorry, I don't want to interrupt.
No, is it in the record?
The discipline that was issued to the colleague that took complainant's position is in the record, and that disciplinary action and expired medication was located on the cart. The disciplinary action was issued because that nurse failed to do the audit on the 15th, not because for months she had represented that the audit was being done. But your observation is the correct one, that obviously these audits are really important, and complainant isn't the only one to have not observed that perfectly, and she isn't the only one to have received disciplinary action for that.
Any other commissioner questions for respondent? Seeing none, thank you. Complainant used all of her time and respondent has presented. So at this time we would turn to the investigator.
Hello, my name is Angela Morse. I was the investigator assigned to this case. After reviewing the record and from the Issues and Resolution Conference, I just simply could not conclude that there was harassment that took place, and certainly not race-based harassment. And I didn't see a link between the reporting of the puncture hole in the medication bottle to any whistleblower retaliation. I'm willing to answer any questions.
Just a real, thank you, just a real basic one.
Yeah.
Could you tell us, or me, what the diversion means?
Diversion, basically, oh, is it? I'm sorry, my audio is kind of bad today for some reason. Did you ask what diversion means?
Yes.
Yeah, so
Yes.
basically taking medication for inappropriate uses. In the bottle of medication, there was a puncture hole, so it looked like somebody had removed the medication, but the fluid level was not down at all. So it was kind of unclear what happened.
Okay, so diversion specifically means that, it doesn't mean problem with the medication.
No, I took, yeah.
Okay. It's
Stealing the morphine.
Thank you. Any additional commissioner questions for the investigator? Seeing none. Thank you, Angela. So commissioners, you've heard from the parties and the investigators. There are two proposed findings here. You can take them together or separately. That's up to you. I would move, I take it together, that we adopt the report that there are no reasonable grounds to believe that Falmouth by the Sea discriminated against Jocelyn Smith on the basis of color or race, hostile work environment. And there are no reasonable grounds to believe that Falmouth by the Sea retaliated against Jocelyn Smith for engaging in WPA protected activity, and the complaint should be dismissed. Is there a second?
I'll second.
So it's been moved and seconded to find no reasonable grounds on both discrimination and retaliation. Is there any discussion among commissioners? Seeing none. So if you're in agreement with the proposed finding of no reasonable grounds on both race or color discrimination and retaliation, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
So the findings are both no reasonable grounds to believe that discrimination or retaliation occurred, unlawful discrimination or retaliation, and the commission will send a letter to both parties and council confirming that, and we thank you for your participation today.
Next is Mariah Toscano or I'm going to say Toscano. I'm sorry if I'm wrong. Versus New Beginnings Residential Care LLC. That's investigators report MHRC number E21-0347. This is a reasonable grounds case, and as a result, we should hear from the respondent.
Yes, they're actually here in person, and I think they are coming in right now.
Great.
Nice.
Slight delay.
Well, you definitely want to turn us off here.
Yes.
There are masks right back there. So sorry about that.
Good morning. My name is John Hamer. I'm here today representing New Beginnings Residential, and I'm here with the owner as well. We're here to oppose the recommended decision. We believe that there was an error of law and on both findings. Now, New Beginning Residential Care is a small residential facility in Milo, Maine. It's got 7 employees total. 2 of them are administrative, and there's 5 personal support specialists. Plaintiff was hired in January of 21 as a personal support specialist. She discovered she was pregnant a couple months later, and she informed New Beginnings. New Beginnings accommodated her for the next month or so. It invited her to submit doctor's appointments to scheduling. It allowed her to reduce her hours from 40 down to, I think it was 16. And she had to leave on a couple of occasions or not come into work because she wasn't feeling well. New Beginnings accommodated her on each of those occasions. Later on, in mid-April or so, the complainant found out that she had a condition and wouldn't be able to work. She informed the employer that she couldn't work, and they asked for a worker's note, a note from the doctor saying that she couldn't work. She finally provided one. It came in around the 26th of April, and it basically said the employee is unable to work at this time. No indication of how long she'd be out or what her status would be in the meantime. The investigator found that there was pregnancy discrimination in this case. Our concern with the investigator's recommended decision is that it did not account for section 4572A, which provides a pregnant person who is unable to work. It's unlawful to discriminate against a person who's unable to work because of a disability or illness resulting from pregnancy or from medical conditions that result from pregnancy in a manner different from other employees who are not able to work because of disabilities. The investigator made no findings about how other employees were treated, and there was no comparison about what this person did and how other people would have been treated. The fact is that this is a very small facility, and there's no way a facility of 5 line workers providing 24/7 care for residents would be able to have a person who's out for months and months and months. But there was no finding, and there's no evidence in the record to discuss how similarly situated non-pregnant employees would be treated. And without that kind of comparison, we believe that a pregnancy discrimination claim must fail as a matter of law. The recommended decision also concludes that there was retaliation. It appears that the retaliation claim was based heavily on the finding that there was pregnancy discrimination. And we think that this must fail as well. There was lots of discussion about whether the employee quit or whether she was fired. And our intention that when the employee brought in a medical note that said she can't work and represented to the employer that she can't work without qualification, with no deadline or timeline in place, that she resigned. She may have said that I didn't intend to quit, but she couldn't come to work by her own admission, and she didn't come to work for a period of time. I think there was a 5-day period before she actually brought in her medical note. So there was no ability for her to work. She didn't come to work. New Beginnings wanted her to work. She just didn't. And if that's the case, then it's hard to say that the person didn't quit. Whether that's material or not, either way, there was no evidence in the record to show that there was any action taken against her because she was pregnant or because she'd asked for some sort of accommodation. The fact is that asking for indefinite leave is not a request for, it's not a reasonable request. It's something that no employer is required to provide. Unfortunately, this person wanted to go out on leave and just let the employer hang and expect to be able to walk into her job months later. And that was something that the employer just couldn't do and is not required by the law to do. So those are the primary points that I wanted to make. I'm happy to answer any questions. And if I'd like to reserve any extra time.
Thank you. The doctor's note that you just referred to. And I believe it probably would be in the record, but if not, the wording of that is that at this time, and The reasoning for, the reasoning is because of complications, exacerbation of symptoms of pregnancy. And if it says that, then it says at this time. Is there a nexus there? I mean, we know it's not gonna be months and months.
Well, it could be months and months and months.
But that's what my question is. Did it say specifically, I mean, specifically the condition that has been referenced is as a result of problem, again, exacerbation of symptoms of pregnancy. And if that's why the doctor said that, that's what I'm asking. I don't know if I'm making myself clear, but.
I'll read to you what the note said.
Okay.
Mariah is currently pregnant and has been diagnosed with hyperemesis gravidarum, something like that. I apologize for that.
Got it.
She has been evaluated in our office and has been seen in our local emergency room on several occasions. Due to the severity of this condition, she's unable to work at this time. We'll update you on her conditions.
Okay.
There's no indication about when she could possibly return. And there was no indication about when she'd even receive an update. So we see this as a request for indefinite leave, and that's not reasonable. But in terms of the pregnancy discrimination claim, again, there's no information about how she's being treated differently from a non-pregnant person with a temporary disability or who would need to be out for 5 or 6 months. And we believe that the pregnancy discrimination claim has to fail on that for that reason.
Thank you. Other questions for respondents council? Seeing none, you have about 5 minutes.
Thank you.
I believe complainant council is Mr. Brock on Zoom.
Correct. Good afternoon. I'm here for Ms. Toscano, who asked that the reasonable cause finding by the investigator be upheld. It's a well-reasoned finding. The investigator did a great job diving into all of the contemporaneous records, going through multiple interviews of witnesses. The respondents incorrect in their iteration of the law, saying that he had to look into whether non-pregnant employees were treated differently. Indeed, the Main District Court in Norris v. City of Portland addressed this very issue, stating that First Circuit precedent makes clear that a plaintiff is not required to show she was treated differently in a pregnancy discrimination case than other similarly situated employees. Rather, that analysis does not apply until after the McDonnell-Douglas burden shifting analysis goes into effect. Once the respondent has articulated a non-discriminatory reason, that is when the burden to show whether or not Ms. Toscano was treated differently than a non-pregnant employee would have played any role. The investigator properly found that respondent did not provide any non-discriminatory reason for the termination of Ms. Toscano. So there was no need to do that analysis according to both the Main District Court and the First Circuit of Appeals. So under the law, the respondent is incorrect in that regard. Similarly, there's nothing in the record to show that Ms. Toscano couldn't have proven that she was treated differently than non-disabled employees. In fact, it wouldn't be hard to show. All she'd have to show is that respondent followed the law when other employees who had disabilities perhaps asked for leave or time off related to a disability. A simple showing of that, which I think we can all assume should have happened, and respondents would have been quick to provide information showing that does happen, would be all that would need to make that test. So there's no reason to reverse the reasonable cause finding, even though there was no reason to analyze it under the test respondent incorrectly cites as well. Related to the retaliation aspect, respondents are incorrect in their assertion in their papers that asking for a reasonable accommodation is not protected under the Maine Human Rights Statute. The Maine Human Rights Statute clearly states that it does. It's clearly within 5 MRS section 4633, which states that it's unlawful for a person to coerce, intimidate, threaten, or interfere with an individual in the exercise, enjoyment of rights granted or protected by this act, or because they had done so. So that's incorrect. Similarly, with the retaliation piece, the investigator found more than just temporal proximity. He also found that based off of respondents' failure to produce a non-discriminatory reason for the termination, and due to certain statements they made when he interviewed their witnesses, that there is evidence of retaliation. So that finding should be upheld as well. Finally, respondents' attempts to re-argue the point they tried to make at the investigation phase, that Ms. Toscano resigned, also fails. This was thoroughly investigated. Again, the investigator looked through the documents, the contemporaneous medical notes, text messages, interviewed the witnesses. All of this directly contradicted respondents' claim that Ms. Toscano resigned. There's text messages saying I didn't resign. There's evidence of communications where she's expressing that she'll be in touch with them, trying to figure out the status of her employment, trying to engage in an interactive dialogue, which respondents don't address at all. But there's an obligation to engage in an interactive dialogue. They have to follow up with her after she gets that doctor's note saying that, she can't work at this time. If they are unclear on how long that should be, they should reach out to her. They should figure out when she can return to work. She tried to reach out to them, and instead they summarily terminated her. The claim that this was for an indefinite leave just simply isn't true. This is a pregnant employee asking for an accommodation for a pregnancy condition. Pregnancy is for a definite period of time, fortunately. It does not go on forever.
Yeah.
And it's a condition that makes her morning sickness worse. Morning sickness happens in the early part of a pregnancy. So it's not even saying, months and months that she'll have to be off. They're saying at this time, her morning sickness is so bad she can't work. Could have been days, it could have been weeks, right? They didn't know the answer to exactly when it would be, but they could have provided an update. Respondents didn't ask for one. They just summarily terminated her. So this finding should be upheld. I'll take any questions at this point.
Questions for complainant counsel, Commissioner David?
I assume you don't object to the third finding that there's no reasonable grounds on disability. If you've got the sex, you don't have disability, right?
Correct. We're not challenging, and we didn't timely submit a challenge to that. I'm asking you to uphold the finding as is.
Thank you.
Additional questions for complainant counsel? Seeing none, I have about 5 minutes when we come back to you.
Thank you.
Mr. Hamer, you have 5 minutes.
Thank you. To respond very quickly to one of the assertions that opposing counsel made, New Beginnings did invite her in to have a talk. And it's one of the investigators' actual findings. He said the manager said you can come in and set up an appointment to discuss these concerns. Complainant said she did not need an appointment. She just wanted a straight answer, and she didn't want to discuss it. So her position was, I am out of work, period, and I'm not going to tell you when I'm coming back. And that is the definition of indefinite. It could be maybe she'll come back tomorrow, or maybe she'll come back never. We don't know that the pregnancy is necessarily going to limit this condition. All we know from the doctor, and what the doctors told us, is that she is out, she cannot work right now. Maybe she can work next week, but they didn't give us that estimate of when she thought the condition would subside and she'd be able to return to work. Had that been the case, then this would be a very different case, because we could have accommodated that. We could have had some discussions, but this is just, I'm out, I'm not coming to work. And eventually she did provide this doctor's note, but it took a very long period of time for her to provide any notes for her request whatsoever. But when she did, then it was this indefinite enough.
I don't want to interrupt you.
Well, it seems like you might be. I would recommend that we let him finish his time and take questions after.
All right, so we definitely disagree that there was a termination at all. And this goes back to a very basic point. When an employee comes to you and says, I cannot work, I am not going to work, And that's it. Even if they say, I'm not quitting, what they are actually doing is quitting, because you're saying, fine, come to work. And they say, no, I'm not coming to work. And I don't know when I'll be able to come to work. So I disagree that there's any termination going on here. The New Beginnings wanted to have her back. She was a good worker. And they invited her to reapply when she felt she could come back to work. But they couldn't guarantee that they were going to keep one of their 5 positions open in order to let her stay off work for months and months and months. Because of the cost, it was going to either you're talking about overtime or hiring new staff. But this is a very, very small operation. So temporal proximity, that's the final thing I wanted to address before we get to questions. The only temporal proximity was between the time the employee said, I can't work, and her not coming to work. Again, this goes back to the termination issue. She said she wasn't going to come to work, and there was nothing that we could have done differently. We could not, she was not going to come to work. We could have said, come to work the next day, and she would not have come to work. So to say that there's a temporal proximity is just incorrect. It was of her own creating. If you want to take a look at the bigger picture, when Toscano first announced that she was pregnant, take a look back to mid-March, because then we were rescheduling her. We were allowing her to reduce her hours. We were letting her call in with little or no notice. And all of those things were being accommodated. But not until the final note, when she said, I simply cannot work, then they understood that she had quit. Because even though she said she didn't quit, she wasn't coming to work and she was invited to work. Okay, I'm ready for questions.
Mr. David?
No.
No? Oh. That's confusing, okay. Any other commissioner questions for respondent?
Can the respondent explain the failure to respond to her April 26th submission of the doctor's note? I mean, as I understand the investigator's findings, the complainant waiting for a response got none at all. Said, look, are you guys firing me or what? It seems like there's a little bit of game playing going on here.
There was communication going on, and there were a bunch of texts, which you probably hadn't seen. But in the end, like I had mentioned, as the investigator found, there was an invitation to have the employee come in and discuss the matter, and she declined. And that was it appears that was on April 26th when the offer was extended. I don't ever advocate communicating by text because there's too much room for miscommunication. So I don't know when people received information, and all I know is there was a request and it was declined.
Other commissioner questions for the respondent? Seeing none. Thank you.
Thank you.
Mr. Brock, you have 5 minutes.
Sure, I'll just address some of the things respondents counsel brought up. And I'll mostly just address it by referring to the report. He seems to be trying to re-argue things that the investigator thoroughly looked into and thoroughly made findings against. The report says, manager's unresponsiveness to complaints queries about the status of her employment and the letter of April 26, 2021 unequivocally showed that respondent had ended complainant's employment, even if respondent's verbiage was not typical of discharging an employee. This was something that was addressed. He looked into the contemporaneous documents. He interviewed the witnesses. He made credibility determinations. He interpreted the documents that exist that are not currently in front of you. And his determination was that the person that failed to respond was not my client, Ms. Toscano, who was reaching out repeatedly, asking about the status of her employment. It was the respondent who failed to respond other than to terminate her. It was their failure to engage in an interactive dialogue. Again, in his report, it says they refused to engage in interactive dialogue with complainant about the status of her employment, which suggests that the respondent's preferred reason for the discharge was pretextual. And similarly, the investigator made findings about whether this was an undue burden or not, and found that it was not. So for these reasons, we find that the investigator's report was thorough. We ask that you adopt it.
Thank you. Commissioner questions for complainants council? Seeing none. Mr. Ashby, you all set?
I am, thank you.
Thank you, Mr. Brock. So we turn to the investigator. Mr. Hurd.
Hello again, commissioners. Good early afternoon. I was the investigator for this case, and just a couple things I wanted to address before questions, which was the first thing was regarding the text messages and whether or not there was a dialogue there at the end. The complainant's attorney, I'm sorry, yes, no, the respondent's attorney, I keep getting them backwards, brought up the fact that respondent said that she offered to come in for a complainant to come in for a meeting. So those text messages are from April 26th. So there was a message from complainant saying, explaining why she didn't want to come into work because of her pregnancy and talking about the notes, and asking if she had been terminated or not. And respondent's answer was, "It's fine. I wish you the best of luck in the future. I hope you feel better. If you'd like to mail the note, you may. If you would like to schedule a spot to meet with me, that's fine as well." So this is in response to asking if she's terminated. There's a few more questions from complainant again, a picture of the doctor's note, and then again just the responses. If you want to set up an appointment to meet with me to discuss your concerns, you may. So that's how those text messages play out. And the next thing was them sending the letter. And then finally, regarding the statement that I cannot work, it was my interpretation based on the text messages that I read and the communication that the statement "I cannot work" was complainant's way of indicating that she intended to take medical leave because of her pregnancy-related condition. It wasn't her way of quitting. And I'm happy to answer any questions that you have.
Thank you. Commissioner questions for the investigator? Seeing none. Any questions? Let's see, none. Thank you, Colin.
Thank you.
So, commissioners, you've heard from the parties and the investigator. At this point, we'd be looking for a motion or motions. There are 3 proposed findings here, so it might make sense to do them separately, or at least in more than one motion. Unless someone wants to make a motion to just adopt all of them. Yes.
Yeah, I'm gonna make a motion to adopt all of them because I think the no reasonable grounds at the end follows the first 2, and I'm moving that there are reasonable grounds to believe respondent discriminated against the complainant on the basis of sex and retaliated in violation of MHRA protected activity, and that there are no reasonable grounds to believe there was discrimination on the basis of disability. The first 2 should be conciliated.
Is there a second?
Second.
So it's been moved to seconded to find reasonable grounds on the first 2 claims and no reasonable grounds on the third claim, at least the way that they're laid out in our report. Is there any discussion among commissioners? None. So if you're in agreement with those 3 proposed findings, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Okay, that was much easier than I anticipated. So there are 2 reasonable grounds findings and 1 no reasonable grounds findings, and the commission will send the parties and attorneys a letter confirming that and describing the next steps in our process. Thank you for being here.
Thank you. Next is our last case to be heard. That is E21-0512 A, B, and C. That's Lana Fields versus Dunkin' Donuts, and then Danielle and Jesse.
Those were parties that we did not have contact information for. We served them at the addresses that we were given. They did not participate in the investigation, but that's all the information that we have for those 2 individual respondents.
This is a no reasonable grounds case, and so we should hear from the complainants.
And Ms. Fields is here. Ms. Fields, I'll just remind you not to use the names of any third parties unless they're a named respondent in the case. You got 10 minutes.
Okay, good afternoon, everybody. I just want to thank the commission for hearing my case. I'm here today. Excuse me, I'm nervous. I'm here today and I disagree with the decision made in my case against Dunkin' Donuts due to the manager Danielle stating in the last hearing that she had to speak with the individual in question several times, Ethan King, due to his behavior towards myself and other employees. Also, the person who sang one little, two little white, one little, two little, three little Indians. Oh, whoops. Hi, Lana. Her name was Billy Joe Hoffman.
It's like those are, we can't take those names in now because the investigation is completed.
Oh, okay.
To us now is not something that we can do anything with. So I'm going to ask you not.
Okay. So that was one of my experiences at this job was experiencing that. And then also with another employee being called little white boy. And while that was going on, I'm hearing this very racial song being sang as I'm at my job at Dunkin' Donuts and how I get to go to school for free and how he grew up in a racist home. Now, how would you feel if you had an issue with an employee and felt discriminated against? So you bring it to management to be addressed, but instead it gets around to all the employees and you become a big joke for everyone by being mocked for being offended by the things being said. So in turn, you feel very unheard and hurt. I tried so many times to address the things going on, but the issues always came back. It made it hard to continue to come forward with any issues that were going on. I was aggressively attacked with syrups, cups, and bags, racially attacked with comments for being who I am. I was also body shamed at this place of employment and targeted for my religion by putting 666 ice cubes and a hot coffee label. And I asked if they would please not do that. And they continued to put 66 ice cubes on the label. Sorry, I'm reading from on the label. I was attacked on anything at Dunkin' Donuts. All this was happening from a shift leader of a branch of the management. After numerous reports about Ethan King's behavior towards myself and other coworkers.
I have to ask you, I'm sorry to interrupt you, but keep using names that you're not allowed to use.
Okay, apologies.
So the only names that you're allowed to use are the ones that you gave us in the beginning that are in your complaint. Dunkin' Donuts, Danielle, and Jesse.
Okay, all right.
Thank you.
So the problem I am seeing is the minimizing of racial discrimination or any discrimination from this company and its management. I don't appreciate my personal experiences with this company are being minimized. And I believe I was discriminated against in this case. And I have heard, okay. I don't know if this is third party, but okay, but I'll leave it out because I'm questioning it. I feel like by not holding these people accountable, it will tell these people and the company that this behavior of discrimination is acceptable and that I myself as a Native American have no rights and can be treated poorly because I'm Native American. I feel I deserve to be compensated for the abuse of discrimination that I endured at the hands of this company, Dunkin' Donuts, and its management. I show up here today to all you commissioners in the last hearing too, because my great uncle told me to stand up with my head held high and use my voice to fight for what is right. That is why I'm here without any representative, because I will use my voice and stand up against any form of discrimination towards me. Thank you.
Thank you. Any commissioner questions at this time for complainants? I'm not seeing any at this time, so you'll have about 6 minutes when we come back to you.
Okay.
And then I believe Mr. Scott is here for at least one of the respondents. Could you let us know which of the respondents you represent?
Yes, so I'm here for Dunkin' Donuts, which just to be clear, though, the two individuals were part of the Issues and Resolutions Conference because they were the managers or management who met with Ms. Fields. So I'm going to be brief. I don't have a lot to add here. I have not heard anything that details any factual errors, any omissions, or errors of law from the investigative report. There was submission in this. We did an Issues and Resolutions Conference where the investigator went through great detail in terms of what was being alleged. And the reality is, as detailed in that report, the complaints that Ms. Fields brought forward were looked into by management. They were addressed with the shift leader, but they were not discriminatory against Ms. Fields. I appreciate and I agree with her that there was her shift leader was inappropriate in terms of and should not have made comments about her, certainly. But the comments that she refers to as racist, such as the thing about one little, two little, three little onions, that was not by any management employee. And in fact, they were not told about it. The complaints that were brought to management were one about her weight, which was addressed with that and conference with the shift leader. And then later, there was a comment made by the shift leader, who was then the manager, about another employee, and that he received discipline for making that statement, but it was not addressed to or directed at Ms. Fields. The management told Ms. Fields repeatedly to come to them with any issues she had. She did. They addressed those. But several of these things, which such as the ice cube incident, which I don't fully understand, but the 666 piece of it was never raised. And so, as I sit here today, this does not rise to the level of harassment that was either severe or pervasive that would give rise to a harassment type claim. And there certainly was no main whistleblower protection activities that occurred here. So I'm happy to answer any questions, but I do think that the report itself is pretty much details the facts of this quite clearly and really didn't miss anything.
Thank you. Questions for respondent's attorney from commissioners? Mr. Ashby, you also?
Yeah, I'm thinking.
Okay. You'll have about 7.5 minutes when we come back to you. Ms. Fields, we're back to you now. If you don't have to, but you have about 6 minutes left if you want to respond or add anything that before.
I feel like things were not handled well at Dunkin' Donuts, and I feel like I endured a lot, and I feel like it's been minimized from day one. I had to fight for unemployment benefits after leaving Dunkin' Donuts, after, trying my hardest to work with a company that I loved my customers in, but I just could not get the staff. Like, I don't know what it was. I was always being attacked, and it would stop for a little bit and then it would come back and it would just start all over. And so that's why I'm here. I mean, I prayed so many days just to get through a shift, not knowing what I was walking into, and management just continuing to minimize my experiences and how I felt. I really am disappointed for how I was treated in 2023 at a job. So I don't know what else to say. I'm not a lawyer. I don't know how to do all this fact stuff and all of that. I just wanted to come here and speak up to my experience, and hope that it's not minimized.
Thank you. Any commissioner questions for Ms. Fields? Seeing none, thank you. Turning back to respondents, you have about 7 minutes.
Yeah, thank you. I don't have anything else to add.
Okay. Then we turn to the investigator, back to Angela.
Hey there, my name is Angela Morse. I was the investigator assigned to this case. Here, much of the offensive conduct, or some of the offensive conduct, was not linked to a protected class. And I didn't find that the objectionable conduct was objectively or subjectively offensive, such that a reasonable person would find it hostile or abusive. And I didn't perceive that the conduct that the complainant experienced was severe or pervasive enough as to alter the conditions of her employment and create a abusive working environment. And I'm here for questions.
Thank you. Commissioner, questions? Yes.
Thank you, Angela. Could you talk about the 666 ice cube thing and how?
Yeah, I didn't, and I still don't know the clear link between the 666 ice cubes and any religious affiliation. I'm not aware of complainant's religion. So I'm not really sure how that's linked. I think it was a kind of a funny prank that the coworkers were, doing at the store, kind of horsing around. I don't think it was directed at anybody specifically either.
Okay, thank you.
Mm-hmm.
Any additional commissioner questions for the investigator? Seeing none. Thank you, Angela.
Mm-hmm.
So commissioners, you've heard from the parties and the investigator. There are 2 proposed findings here. Is there a motion or motions? There we go. Go ahead.
Okay. I think I have to say that I agree there are no reasonable grounds. I'll take them together. No reasonable grounds to believe that Dunkin' Donuts discriminated against Lana Fields on the basis of race, color, ancestry, and/or religion, hostile work environment, and that there are no reasonable grounds to believe that Dunkin' Donuts discriminated against Lana Fields for engaging in WPA protected activity, and the complaint should be dismissed. I'd like to speak to that when it's appropriate.
First, we need a second. Is there a second?
Second.
Okay, it's been moved and seconded. Is there any discussion?
Just to say, Fields, that I hear you about that it feels like it was minimized. We need to direct it clearly to the Maine Human Rights Act, and I just don't see that. But I do appreciate. I just want you to know that I for one, and I don't believe anyone else here, is based on our vote diminishing and minimizing what you have gone through. Good.
I just want to second what Commissioner O'Brien just said. I am sensitive, and when you say, are we minimizing if we don't find this to be discrimination? Our legal standard is, did it create a hostile work environment because it was severe and pervasive?
Severe or pervasive.
Severe or pervasive. And I don't see that, although I agree that it's was inappropriate and offensive.
Yeah, I'm just gonna go ahead and add to what's been expressed and just say, I enjoyed your comment about using your voice. Keep using your voice.
Thank you.
Any other discussion among commissioners? Seeing none. So the motion is to find that there are no reasonable grounds related to race, color, ancestry, and or religion in a hostile work environment, and no reasonable grounds to believe there was retaliation for engaging in WPA protected activity. If you're in agreement with both no reasonable grounds findings, we'll vote yes. Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
So the findings are both no reasonable grounds to believe that unlawful discrimination or retaliation occurred. The commission will send the parties and attorneys a letter confirming that, and we thank you for your participation today.
Pursuant to one MRS section 405(6)(e), I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission. While we make that change, I'm going to take 5 minutes, please.
Wait, we need no. we vote that.
Oh, I'm so sorry. Yeah, I assumed the vote would go the way I wanted to, but I guess I probably have to
First,
say.
First, we need a second.
I'll second.
Okay.
I decree.
You're a commissioner.
You never know when people aren't. They might say no.
Yeah.
So it's been moved to go into executive session. It's been seconded. Is there any discussion among commissioners? Seeing none. If you do want to go into executive session, you'll vote yes. Commissioner Ashby.
Yes.
Mr. David.
Yes.
Commissioner O'Brien. No.
Doesn't matter. Still going to the back. Yeah.
That was good stuff. Really, high quality.
I may come back.
High quality. Is the mic on?
Yep.
All right, so we're back in executive session, and at this point, is there a motion related to litigation?
Yes.
No, please, go ahead.
This is the correct caption. I thought you might have said that this was.
It's the wrong caption, the
The number
wording.
is correct.
So
The number, no, the number is
All right, I move that we litigate MHRC case H 22-011.
no 0253 A and C.
Oh, so this is wrong.
That that is wrong.
Okay, so what is it? 0253?
0253 A and C.
A and B.
A and C.
A and C.
B is closed.
And that we not, or are you gonna do them separately?
No, and that we not litigate E 210021 Hobbs versus Leon.
Excellent. So it's moved and seconded to litigate H 220253 A and C and to not litigate E 210021. Is there any discussion among commissioners? Seeing none, if you're in favor, you'll vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Okay. And there's one last matter which carry over. Yes.
I was going to address that. I move that we deny the request for new investigation in H 22-0297.
295.
It says 297 here. Is this wrong?
Oh, or it could just be that I typed.
No, I have fine. That's it, up the top.
So are you related? Are you talking about Perel versus Warren?
Yes, I am
We
talking
can
about
clarify the correct case number.
deny the request for new investigation.
Second. Been moved and seconded to deny complainant's request for a new investigation in Perel versus Warren. Is there any discussion among commissioners? Seeing none, if you are in favor of the motion, you will vote yes. Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yeah.
Okay, I believe that is the last matter, and that you don't need a motion to adjourn. You can
So next meeting is
July. I believe June
26th.
Hold on.
That was a day. That was a day.
June 26th.
June 26th.
Spicy meeting.
And I will be in Canada. So if you want, if I Zoom, I do that public, that's first email that you send to everybody. It's going to be by Zoom.
Yep. All right, everybody.
Did you say spicy? That one?
It was spicy. Spicy meeting. I enjoyed it. All right. See you all. Thank you.
Bye.
Bye.
Someone put salty?
Okay. I'm gonna end this.
Oh, that would be a good idea.
Thank you, Jeff.
Sorry, I forgot it was so long.